Good afternoon, everybody. Welcome to Good Logic. Today, we are going to be watching perhaps the most hotly anticipated testimony since the, Depp Heard trial. This is something that the whole world wants to see. Everyone and their uncle wants to see exactly how today's events are going to transpire in Fulton County Superior Court. And we are going to watch it. And I thank you for participating and joining me as I sit here trying to break down for you exactly what it is we are witnessing going on in court in real time. Now, just those of you who are a little bit behind, not sure exactly what's going on, a few things I want to explain to you about what we should anticipate today. At the very least, we know that Nathan Wade's former business partner, law partner, divorce lawyer, longtime friend for decades, who has taken the stand twice so far. First time got cut short with all these claims of privilege. Second time, he was clamped down and kept saying privilege, 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 privilege. Anytime he was asked any questions about the relationship and what he knew of the relationship between Wade and Willis. And that claim has now been, at the very least, reduced. I will anticipate for you, there's a very strong chance that we still may hear some claims of privilege that the court will sustain. Because what the court did, after it saw that Bradley was applying the term privilege far too broadly, after he saw that, look, this is not something that you're saying privilege even when Georgia law does not say privilege attaches. And he knows this because he held an in-camera, means like in chambers with the judge. He had a conference with him. It seems like the judge knows a lot more than we know at the moment for certain as to what knowledge Wade has of the relationship between that Bradley has of the relationship between Wade and Willis. That does not mean that the privilege is gone. Privilege is exactly where it was before this whole hearing started. It's just a matter that the judge now has a better understanding as to when Bradley has a proper right to assert attorney-client privilege. And that presumably, with a deeper understanding of what Bradley knows and what the source of his knowledge is, that the court now is in a better position to guide Bradley and say, this one you have to answer, that one you don't have to answer. So we may see privilege asserted. I would expect his attorney, meaning Terrence Bradley's attorney for purposes of this hearing, to pop up frequently asserting privilege. And the reason he may do that, the reason I would anticipate it, I'm thinking to myself, if I was Terrence Bradley's attorney, I would want to go on the record making it clear that my client does not want to testify to this question, that question, this question, that question, because it's protected by attorney-client privilege. And that would be Mr. Chopra. Chopra is Terrence Bradley's attorney. That would be Chopra's way of protecting Bradley from Wade ever coming and filing a complaint against him with an ethics committee saying that he did not properly stand up for privilege when privilege ought to have attached. So what I expect to see is we likely will see that Chopra will stand up, claim privilege, and the judge may allow the defense to ask further. He might just say overruled. It'll probably depend. And the judge has been very on top of things. Question by question. He has not slept for even a moment of testimony. When there's a question which goes too far as like asking anything outside other biases that Willis might have, anything regarding money. Excuse me, I'm not taking this. I'm going to turn this off. But anything at all which walks away from what the judge cares about, which is specifically, was this prosecution motivated by Willis's desire to try and enrich herself and or her boyfriend. When did he become her boyfriend? Or anything that strays away from that, he has very quickly clamped down, meaning questions as to whether she acted with propriety as far as notifying the state. He was parsing out. He's like, okay, to the extent it goes to impeaching your testimony, that's okay. To the extent it's trying to show that she's failing to follow proper regulations, that's not what this hearing is about. And you could see his brain churning, question by question, intelligently. I'm not saying this in any way as a way of deriding the judge. Quite the contrary. He's earned respect because he seems to really be trying very hard to handle this appropriately, to figure this out properly, and to actually implement justice. And is he beyond reproach as far as his being biased this way or that way? There are reasons, if you're on the Trump train, to think, oh yeah, okay, so he worked for Fani, he gave money to her, he knocked out all these different reasons to have a hearing, such as issues as to the fact that this was basically a publicity tour for her, and all these different claims that none of this is relevant to the hearing that he allowed to go forward. These are all reasons that people who are on the Trump train may come to a conclusion that MacAfee is in the tank for Fani Willis and Nathan Wade. But if you're sitting on the other side of the aisle, if you're sitting there and you're hoping to see Trump's hide nailed to a wall, there are a lot of things that MacAfee has done here which make you outraged and think to yourself, why the hell are you allowing this to go forward? A lot of judges would have seen this motion and said, I'm not having an evidentiary hearing. All this is just salacious scandal, and they just would have closed their eyes to it. But not Judge MacAfee. He didn't do that. He carved out a lot, but he didn't carve out this part of it. Ironically, from my perspective, one of the weaker parts of the claim, as far as trying to look into the mindset of a Fani Willis, to me, it makes a lot more sense to suspect that she's motivated by her own political fame and good and fortune and publicity as the woman who scalped Trump, than to think that she wants to get a couple of shekel into her boyfriend's pocket. But it does seem that's where he drew the line, and he's allowing this hearing to go forward. Many judges would not have done that, knowing full well that he was going to get flack for it. Not only did he do that, but then when Bradley was on the stand, he could have turned a blind eye when Bradley tripped up his own tongue when he was on cross-examination by Assistant District Attorney Anna Cross. And he revealed during the course of his testimony that he didn't know what privilege was. But it was, if you weren't paying very close attention, you might have missed that he made that revelation. Meaning, Anna Cross started asking him questions. First, he said, I can't talk about why I left Wade Bradley Campbell because it's privileged. A lot of things happened. And then later on, like an hour and a half later, he started talking about why he left. And it became clear that that really wasn't privilege. A lot of judges would have just forgotten that he had claimed privilege earlier, not seen that Bradley exposed himself as someone who is attaching the label privilege to things that are not privileged, but not Judge MacAfee. And that kind of surprised me, because I kind of started with an assumption that he's a little bit in the tank here for Fani Willis. A lot of judges would have actually forgotten that he had said privilege earlier and failed to realize that this is a man this is a lawyer who doesn't seem to know where privilege attaches. Or they would have pretended to have forgotten about it, but not Judge McAfee. So I think I think that from everything we've seen, my current takeaway is this is a guy who's trying to do right. He's trying to do it right. And I respect that. I have great respect for that. I'm going to try and figure out what is the best feed. I need to have I want my feed to basically be that if I'm talking, you'll hear me slightly over the trial, because I don't talk over the testimony. I don't talk over the testimony. To me, the main feature here is definitely not me. I'm like 20th on the list as to as to importance here. But if I do interject and you can't hear me, there's no point to me sitting here, right? So I'm going to try and get adjusted court levels. I'm going to pull up the Superior Court. I'm going to pull up the live proceedings here, Judge MacAfee. And nothing's happening in court yet. It's supposed to begin in 3 minutes. And I'm going to just pull this up here. You don't have it yet. Let me present, share screen, entire screen. Oh, no, I got to redo that. You're not going to have audio at all. I missed a button. Okay. So this is the court feed that we have going on there. I don't hear anything yet either. Now you hear people talking in the back. I was afraid I would not be. I'd be afraid. I'd be very afraid. Text vet. Let's go. Since you're not a leader of the cult, I'm not a leader of the cult. You're not in a position to tell us it's not a cult. I'm one of the early members. I need to think that one.
Here, so I gotta move that mic some without speaking. It's on.
It needs to look down some. That's not someone talking into the mic. I'm going to look to you all to sort me out. This is a vacuum power. I guess I'll lead if you want. Don't worry, it's not a coup type of coup. It's like a J7 coup. It's a J7, not J6, J7 coup. That's really funny. That was really funny. Yeah, I yell just like Sadow's. Stop yelling. Stop yelling at me. It's showtime. Cue Beetlejuice to whoop the fanny pack. If she is flat and we get a day off, and that's true. We will. I'm going to tell you this. This is what's interesting to me. And I am going to cover next week, March 7th, is going to be the ethics appearance. And I will be live streaming that as well. That's going to be on March 7th. So I will be live streaming that. I urge you to please make sure you like and subscribe. So this way you'll be able to get all my coverage, not just on Fani Willis and Trump, but I have a nightly show from 10 p.m. to midnight Eastern time, 6 nights a week. So yeah, you're never going to find me again. If you're new here, you just stumbled on me. If you don't like and subscribe and turn on notifications, you're probably never going to hear from me again. So, and that would make me sad. So let's remedy that. There's no need to yell, Joe. Please stop yelling. Thank you for the super sticker, Zajac. When comments come up during the course of testimony, I am not going to read them out loud. If there's something that merit, I'll pull them up. But if they merit response, look, a larger super chat I'll save for later. If they merit response and they need response, I will definitely pull them up after the stream. But I can't stay long after the stream. Just warning you about that. I got a party tonight I have to get to. Joe uncovered fraud in camera piercing AC attorney-client privilege. Oh, Joe uncovered fraud in camera piercing attorney-client privilege. The judge uncovered fraud in camera pierce. It's not piercing. That's why I want to be clear. I tried to explain this distinction yesterday. What happened with Trump is then his lawyers being pulled in. His lawyers had a rock solid privilege. All the communication, as far as we know, between Trump and his lawyers was for the purposes of them being able to better represent him. Attorney-client privilege certainly attached. And the district attorney went ahead and pierced through it on a basis saying that we're going to take it away because you're trying to work in concert in criminal activity with him. It's there, but it gets pulled away because of the fact that it's being abused for the purposes of furthering crime. That's very different from here, where the judge is like, there never was, there was and is the same level of attorney-client privilege. Whatever, but it's not that every communication has privilege. Some communications between you and Bradley are going to have privilege. Others are business partners talking. Others are friends talking. And privilege never attached to that. Just because you pretended that there was privilege on it doesn't mean that every time she mentions Fani Willis to you, there's privilege. And there never ever was a privilege there that's being taken away. It's a very important distinction. Williams, member for 10 months. Come join the cult. Bring sweats, tracksuits, sweatsuits. That's why I should get to. Should get all of that. New member, Happy Hippie. New member of the cult. All right, here we go.
Thank you all. Please be seated.
So now, volume levels. Let me know. That's Steve Sadow there. He's awesome.
All right, we are back on the record with 23 SC 188947. If we could have counsel starting with the state identify themselves for the record for the purpose of today.
Turn the court feed up.
All right, and in order of the styling, let's start with former President Trump. I think we have Mr. Sadow on Zoom.
You do, Your Honor. Good afternoon. Steve Sadow for President Trump. We waive his presence, and I believe Ms. Little is also on Zoom. And
Great comments.
Okay, thank you, Mr. Sadow. On behalf of Mr. Giuliani.
Alan Stockton on behalf of Mayor Giuliani. I think David Lewis and John Esposito may be on Zoom as well. And we waive his presence.
There we go. On behalf of Mr. Meadows.
Your Honor, Jim Durham on behalf of Mr. Meadows, and he waives his appearance.
Thank you, Mr. Durham. On behalf of Mr. Clark.
Harry McDougald, Your Honor, and he also waives his appearance.
Thank you, Mr. McDougald. On behalf of Mr. Cheeley.
Good afternoon, Your Honor. Richard Rice, President Court, Chris Anulowitz is on Zoom, and Mr. Cheeley waives his presence.
Thank you. On behalf of Mr. Roman.
Good afternoon, Judge Ashley and John Merchant on behalf of Mr. Roman, and he waives his presence.
All right. On behalf of Mr. Schaefer.
Greg Gillen and Anthony Lake on behalf of Mr. Schaefer, and he waives his presence.
On behalf of Mr. Floyd.
Morning, Your Honor. Good afternoon, Your Honor. Chris Kachuroff and Mr. Floyd. We also waive Mr. Floyd's appearance.
Thank you, Mr. Kachuroff. And on behalf of Ms. Latham. Anybody here on behalf of Ms. Latham? All right. I know before we'd had Mr. Cromwell, and I had not heard anything from him. I don't know if any other parties have as well, but.
Your Honor, I believe Mr. Cromwell is in a deposition in South Georgia. That's all I know.
All right.
There's a Zoom participant, Mr. Cromwell. Looked like he joined.
Okay, that's helpful to know. Mr. Cromwell, can you hear us? All right, well, we'll keep an eye on that to see if he does join us. And we'll take it up as it comes. So, just a few preliminaries. First of all, I'm a bit under the weather, so I'll try to speak up, but if anyone can't hear me, just let me know. I'll try to talk close to the microphone. But we are here today, the sole purpose of which is that at the conclusion of the hearing on February 16th, I announced that I'd be meeting with Mr. Bradley in camera to assess the validity of his assertion of attorney-client privilege. I've now been able to do that, and I also allowed Mr. Wade the opportunity to weigh in and respond as well. And after considering the testimony, not only in camera, but also of what came out at the hearing, I found that neither Mr. Wade nor Mr. Bradley had met their burden of establishing that the attorney-client privilege applied, specifically as it relates to Mr. Bradley's knowledge of any relationship that existed between Ms. Willis and Mr. Wade.
Nice. Nice. Exactly what we want.
Particularly that it wasn't established that his specific knowledge came about in furtherance of legal advice. So having made that determination, I didn't see any other choice but to allow the parties to have an opportunity to explore that topic with him. There's really, in my mind, it's that topic only. I think that if there's anything else we've already covered, I'm not here to do it again.
By the way, Anna Cross is gone.
Is there anything else
she
we
fired?
need to cover before kicking that off?
Just Mr. Wade, he's still a potential witness, I would assume. And so he needs to still be excused. We would invoke the rule continuing.
Mr. Avani?
Yeah.
I believe Mr. Wade was released from his subpoena when we concluded his testimony at the last hearing. So unless he's been re-subpoenaed and I have no knowledge of that, he has every right to be present.
Sure. I think procedurally that would be accurate. And so I at this point, I don't see a means where he would need to be recalled. And but if it is, then that is something you can take up. All right. Mr. Bradley, through his attorney, had informed me that he would be here today in person. I don't see him in the gallery. Do we know if he's out in the hallway? Okay.
Thank you.
All right. If we could call for Mr. Bradley.
Yeah, I agree with you. I would have cut him out. I would have sent him out because he just said that he might be subject to recall. So that's a benefit to Wade to be able to watch what Bradley says
fine.
and try and tailor around that.
All right, Mr. Bradley, Deputy Scott will swear you in again.
There we go.
I do.
Please be seated. First and last name for the court.
Terrence Bradley, Terrence Bradley, Bradley.
Ms. Merchant.
Thank you, Judge. Good afternoon, Mr. Bradley.
Good afternoon.
Good to see you. Sorry, under these circumstances. I'm going to just go straight to where we left off before. Fani Willis and Nathan Wade were in a romantic relationship, correct?
Correct.
And it began at the time that they were both municipal court judges, correct?
Objection, Your Honor, based on privilege. That was covered in the attorney.
Okay, overruled.
See, I told you.
I do not
Objection,
have knowledge
overruled.
of it starting or when it started.
Terrence, you told me that it started when they were both municipal court judges, though, correct?
That is incorrect.
You never confirmed in writing that it was instead of magistrate court, it was in municipal court when they started dating?
If you're speaking of the text message, you can go to that text message and you can read that text message and I will explain the text message to you. But you and I did not have a conversation about when it started. You asked a compound question of magistrate court versus, you said it was magistrate court, you said magistrate court conference, I'm sorry. And then you asked another question. I said, no, municipal court, nothing else.
I'm referring to a different conversation. I asked you, do you think it started before she hired him?
And I'm going to object. This was covered in the previous hearing where Mr. Bradley said he had no personal knowledge of the exact text that Ms. Merchant is speaking of and actually used in an attempt to refresh his recollection. And he explained exactly what he's explaining here before the court. So this is repetitive and unnecessary. And so I would object to asked and answered and relevance at this point.
All right, perhaps we'll get there, but I think first, Ms. Merchant has the right to draw his attention to the exact, potentially inconsistent statement.
Thank you, Judge. May I approach him?
So overruled. You may.
Oh, you can see it.
Come on, Ashley.
Okay, you at the last hearing.
Let's face it, we're all waiting for
And for
Sadow.
purposes of the record, I believe, Ms. Merchant, you tendered, was it the entire text chain as an exhibit?
I only tendered a few of the texts, but I did give the state their courtesy copies last time of the exhibits.
Was this one tendered?
This one was not.
You don't have to
All right.
do
And I'm
this. You
happy to
can.
tender
Why
it.
not just ask the
Well,
question
just
afresh now?
Take it as it comes.
Just
Whatever
ask
you
We're
want.
at,
right now.
I think
Did the relationship start before
39.
November 1st?
I will wait to mark it.
It's your
I think we're at
knowledge.
39. May I approach, Judge?
You may.
It's like you don't have to sit here going through what he said to her, what he didn't say to her. If he didn't say it to her, it's still you can ask the same question. You don't need to establish this. If he denies it that it started before November 1st, 2021, the day that Wade was hired, then you come in with this stuff. You don't. She's doing this so poorly.
All right. So Terrence, do you remember telling me that it started when she left the DA's office and was a judge in
Maybe.
South Fulton?
I see the message there, but I don't recall. I do see that message, but I do not recall.
True.
You don't recall texting this?
I look back at my text messages through that we've had. I see that message, but I do not recall that. No, ma'am.
And when I asked you if you thought it started before she hired him, and you responded absolutely.
Your Honor, I'm going to object as to the source of the information that Mr. Bradley allegedly gathered this from. There's been absolutely no foundation, and based on the arguments at the last hearing, that a lot of this is based on gossip, innuendo, assumption.
More speaking
and
objections.
privileged information. And at this point, Ms. Merchant has not provided a foundation as to how Mr. Bradley would have any information that she keeps referring to.
All right. I think
If I-
that's, go ahead, Ms.
fair-
Merchant.
I didn't ask him about the source of the information. And under Rule 621, I can impeach him with any inconsistent facts. This is an inconsistent
He's not being
fact. I can
impeached. You didn't
impeach him
show
with
that he
any
said anything
contrary
wrong.
facts.
Sure.
This is a
Why would it
contrary
be
fact.
a relevant impeachment if he actually has no personal knowledge of this?
If he doesn't.
Sure.
have
So I
personal
think you have to lay that foundation. then, so
Yeah,
this is saying.
exactly.
knowledge.
Do it right.
Do you remember telling me that it began?
Well, that doesn't address the.
No,
Who
I was asking
cares?
if you remember telling me as opposed to the
Okay,
text.
sure.
Do you remember telling me?
No
that
one
it
cares what he
began-
told you.
Well, no,
just
and then
care
you're
what
going
happened.
into the substance of it, which we haven't determined whether he actually knows or how he knows.
You told me. In fact, you corrected me when I said magistrate court. You corrected me and said it was municipal court. Do you
Yeah.
remember that?
Just
Same
tag-
objection, Your Honor.
This is the exact same issue.
Tag
right?
Sadow
Well,
in.
I'm asking if he remembers that. He hasn't answered that question yet.
Right, but the relevance of whether he remembers it isn't established until we know how he remembers it or why he knows it.
Thank you.
If that makes sense. I guess not.
Sorry, how he knows it. I'm just asking if he told me that.
Right.
So I wasn't asking how he knew that. I wasn't asking the source of that knowledge. I
He
was
said
asking if
already he
told me
didn't
that.
tell him.
That was it.
But that's the point. It's how he knows it.
Right.
The source of his knowledge, the state would contend is hearsay because it's gossip and innuendo, which is what was indicated the last year.
Well, it may not be hearsay. It may not be gossip. We haven't really gotten there yet. We don't know how he knows what apparently he's telling her. And I think we need to figure that out before we can go any further.
Yes, and if the source of the information is a witness who's testified, then it's not hearsay. So when did the relationship start?
I cannot answer that.
When was your first knowledge of the relationship?
Objection, Your Honor. He's already answered that question multiple times today. He said he has no idea the timeline or
That's
when
not what
it
he
occurred.
said.
That was one of the first questions
No,
that
it's-
Ms. Merchant asked.
I didn't ask when, I asked his first knowledge. He testified he has knowledge that they had a relationship. I asked him when he first got knowledge of that.
Okay. So if the question is, when did you first get knowledge? I think
That's a new
we can
question.
start there.
That was the question. Yes.
Finally, getting
Thank you.
somewhere.
When did you first get knowledge of their relationship?
I've said over again that I didn't have any personal information where I could personally say when it started. I've said that time and time again. So I don't know when the relationship started.
And that wasn't my question. So my question is, when did you first gain knowledge? I didn't ask the source of the knowledge, didn't ask you to comment on the validity of the knowledge. I asked
Well,
when you first had knowledge.
We'll get to the how, Mr. Abadi. So I'll note the objection, overrule it. You can answer that.
And just for the record, and I appreciate Your Honor. But he said he had no personal knowledge, so he had to gain the knowledge not from hearsay.
He could have gained it from
Sure.
Mr. Wade.
Well, I mean, most of
Statement
us
against
learn
the
things
truth.
from hearsay. The question of whether it's admissible, right? And that's what we got to get to. So
When did you first learn of the relationship?
Apologize.
When did you first get knowledge? I'm not qualifying what type of knowledge. I'm just asking when you first knew about the relationship.
Finally, a good question.
I don't know how to answer that. I mean, so
You do know how to answer it. Just give it time.
I can't give you a date if you're asking for a date. If you're asking me,
Ask a
how
year.
did I get the knowledge?
Jesus.
It would have come directly from my client.
Right.
So
What
help me
year?
understand.
I think you say you can't answer that question. You don't know the date. So that's the answer to the question.
What
But
year?
I said that 5 minutes ago.
Jesus.
We have to make it clear.
Yes,
All
sir.
right. Next question, Ms. Merchant.
So you don't know the specific date.
No.
Do you know if can we narrow down the timeline? Did you gain knowledge in 2019 of this relationship beginning?
I'm gonna object to this line of questioning as he said he does not know
Sure.
when he gained.
All right.
knowledge.
He doesn't know
Overrule-
the specific
That's
date.
fine, Ms. Merchant. I think I'm overruling that. I think we can try to see if he can narrow it down based on
Thank you.
goalposts.
Thank you.
The judge has to hold her hand.
19, I would probably say no. I mean, I don't have anything that I'm
Just start with 2021. Work backwards.
there wasn't a specific date. There wasn't a football game. There wasn't something that I can attribute to him telling me whatever. And so you're asking for a date, you're asking for a year, it's still a date. And at this time, I am telling you that I do not have the date.
Let's try this then. So you received a contract from Ms. Willis, January 2021, correct?
Can I see the,
Yes,
yes, I think so.
Exhibits are, I think, okay.
I think
And-
if it was
At
from
that time,
the
were you
exhibits,
aware?
I think it was 21, yes.
And I don't want to belabor the point, but that those,
Yes.
when you were here before.
Yes,
If those documents that you looked at
At
last
that time,
time,
were you
Yes.
aware that
said
they were in a
January
relationship?
2022, that's, okay.
21. I
I'm
didn't,
sorry, 21, you're right, thank
and
you.
it was, I think, renewed in 22.
It was, yes. So the contract date was, that we have in the record is January 25th, 2022. So using that date, at that point, had they begun their romantic relationship?
Of 2022,
January 25th, 2021, I'm sorry. When you got your first contract?
I don't recall, I don't recall any specific dates. No, ma'am.
You remember when you got that contract, though, correct?
I remember I had the contract, yes.
Okay. And you told us last week, or I guess it was the week before now, you told us that Mr. Wade
He totally
brought you that
knows.
contract,
He's such a
essentially told you about
liar.
that contract.
Don't perjure yourself.
That is correct.
So Ms. Willis is not the one that brought that contract to you directly. It was Mr. Wade.
That is correct.
At that point in time, they were already engaged in a relationship, though,
I'm
correct?
gonna object, Your
I
Honor.
can't say that.
Characterization of what Mr. Bradley just said. He just said he does not remember. There's nothing specific.
He doesn't remember the exact date. And I think the question now is to reference it or tie it to maybe some other event that he might remember.
I agree with Your Honor. She asked that specific question. He said he does not remember.
Oh my
any
God.
Specific dates after signing the contract. That's exactly
Sure.
what he just said. This is
All right.
asked and answered.
I know, and we're getting to the end of it. So, Ms. Merchant, you don't have much more to pull on here, but he answered that last question. So what's your next one?
And Judge, I didn't hear the answer if they were in a relationship January 25th,
Mr.
2021.
Bradley, do you recall the question?
I recall the question, and I can't tell you accurately whether or not they were in a relationship at the time. You asked me about him bringing me a contract. I said he did bring me a contract, and that is accurate.
Do you remember knowing Ms. Willis prior to her taking office as the DA?
I had very little contact with Miss Willis. I knew her through my business of coming down to Fulton, if that's what you're asking. Yes,
You knew her through the business. So you had met her prior to your contract?
I'm gonna object to relevance at this point as to why we're here today.
Sure.
Judge, he doesn't remember much of anything right now. And so I'm trying to create a timeline to hopefully piece this together.
All right. Well,
Just pass the baton to Steve Sadow.
I'm not seeing really the likelihood that that's going to have any success. I'll let you ask a few more questions, but if he doesn't have a date, then I don't know that you're going to be able to create one today.
Okay, thank you.
Please. Did you learn of their relationship in 2021? It's very
So the
easy.
time that you had this contract from January 2021 until January 2022, did you come in and out of the DA's office?
Oh my God.
yes.
Okay, and so were you able to witness Mr. Wade and Ms. Willis interact during that time?
I'm gonna object. This has been asked and answered. It was addressed at the last hearing about Mr. Bradley's access to and from a specific room to pick up files. And Mr. Bradley said that
Sure.
he rarely saw them together, but this was
Yeah,
answered.
I think the only avenue that was closed at the last hearing was his personal knowledge, potentially through, well, actually, no, if he testified, it was that he had no personal knowledge. It's knowledge that conveyed to him that was cut off at the last hearing. That's really the only thing we hadn't been able to explore, unless you're correct correct me if I'm wrong,
Knowledge that was conveyed to him by,
by somebody else. That's that he claimed at the time was privilege. I found that it's not. That's what we're here to explore.
okay.
If you can figure out how to ask a question.
Do you remember telling me that not many people knew where they met?
I'm going to object as to relevance. As
She's
his
back to
personal
what their
knowledge, which is what
conversations.
602 requires.
Yeah, I mean, we're back to the same point, Ms. Merchant.
His personal knowledge is what I'm asking him what he told me.
But he hasn't yet told you how he knows that. And so if, unless you can establish why he should be testifying on this at all, then there's no relevance.
And I don't know how he knows that. That would be
Then
the
ask
next
him.
That would be the next question.
Then
But
ask him how he knows it.
I first have to establish that he said that.
No, you don't. You could go the other way around.
When you told me that it started when she left the DA's office and was a judge in South Fulton, where did you gain that knowledge from?
Well, I'm going to object because his testimony a few minutes ago that he did not recall making that statement.
I'll overrule that. Mr. Bradley, answer the question if you can.
Repeat the question.
When you told me that their relationship started when she left the DA's office and was a judge in South Fulton, where did you obtain that knowledge from?
I was speculating. I didn't have a no one told me I was speculating.
No one told you that?
No one told me that.
You were speculating based on things that had been told to you or things you had observed?
What caused
I'm
you
going to
to,
object as to the nature of
what was your
of this line
speculation
of
based on?
questioning, because the witness has made it clear he was speculating
Okay.
as to how or what he knew.
What
And
was
if it's
speculation?
speculation? It's inadmissible before this court.
All right, but the motivations for his reason for speculating would be admissible, so I'll overrule that.
Precisely.
Judge.
That's what you need to ask.
Was this speculation when you told me that?
No,
Was that based
good,
on
wrong
things that
question.
had been told to you and things that you had witnessed?
What caused you to have
I
that
never
speculation?
witnessed anything. So, it was speculation. I can't tell you anything specific if that's what you're asking.
Tell me anything specific as to why you speculated about that?
No, this was however many years ago. I mean, I don't recall, but no, I don't.
Did you have any reasons why?
What? Oh my God.
I don't know if speculation is lying, but
Well,
What is the basis
don't
of
worry,
your
Ms. Texas,
speculation?
speculating, or
you didn't
know?
ask me if I was speculating or guessing.
I didn't ask you, but tell me if it says anywhere here that
No,
this is
it-
speculation.
If this is the same one that you just showed me, it does not.
All right, you're fired,
You're
Ashley.
welcome if you need to look at your text. Is there anywhere in here that indicates that you didn't have knowledge of the
No.
relationship?
Your Honor, I'm going to object. The line of questioning Your Honor directed counsel to explore is where he got the knowledge. She's explored that. He said it's speculation and he didn't get it from any source other than his own speculation.
Sure.
So ask
I think
what-
we're fleshing that out. And
Why don't
it's
you
her right
ask?
to
The judge even told you
have a
the
little
question
leeway
to
on
ask.
this if he's an adverse witness.
Thank you, Judge. And Judge, these speaking objections are clearly coaching the witness because he's regurgitating.
Your Honor, I
What-
object and take offense to that comment. I'm objecting based on the law and I'm making a record for the court.
All right.
So I take offense to that comment. It's not the case.
It is
All right,
beneath me
Uh,
to be
I
coaching
think
the
we can
witness.
start with objection, the grounds and the rule number. And then if I need more, I'll ask.
Yeah.
Thank you.
All right.
Good.
Thank you.
Finally, Ashley.
What did Nathan tell you about the relationship?
Objection, hearsay.
Nathan has testified. It's
Yeah.
not hearsay.
It's still hearsay. It's an out-of-court statement being brought in
It's
for
to
the truth of
impeach
the
him.
matter asserted. So hearsay.
Judge,
All right. Yeah, this would be for impeachment by contradiction, which would
Thank
be an
you.
exception to the hearsay rule and admissible as substantive evidence, and the privilege issues are overruled.
thank you, Judge.
Well, I think you just overruled the privilege objection. But we don't know when he's talking about, so we've already established the December
Right.
2018 privilege.
Sure. And that's something I covered in the in-camera hearing. And
Judge-
I'm, based on what he told me in that in-camera hearing, I don't believe any statements to this effect We're covered by privilege.
No, I
And
think the
I just
judge is
want for the
being
record, because sometimes the
generous
record
to
doesn't
Ashley
reflect where
Merchant.
people are looking, and that when I ask a question, Mr. Bradley is looking at Mr. Wade and his lawyer to wait for them to object, and they're clearly interacting somehow in the court. So I just
Oh
want the
my
record to
God.
reflect that, because it wouldn't otherwise.
It's there now.
Thank you.
Do you have a question was put to you, Mr. Bradley?
Judge, one of my lawyers is sitting right in the back,
We
that's
don't have to go
behind.
down that rabbit hole. You can look wherever you want.
Yeah, and
We're gonna
I've
get there.
never looked at
We'll get there.
Mr. Wade or his attorneys. That sounds Scott Street.
All right. Mr. Bradley, question was put to you.
Repeat the question, please.
Yes, so I showed you, or I asked you, I'm sorry, the last question I asked you was, what did Nathan Wade tell you about the relationship?
Same objection, Your Honor.
And that's already been ruled upon.
I recall him stating that at some point they were dating. I can't tell you what date that was. It was made in confidence. We were in the back of our office. Our offices were the only two in the back. There was no one else present. That is all I can tell you at this time.
Well, tell us more about that conversation, so we can figure out
One
whether it's.
time?
One time.
You only had a conversation with him one time about the relationship?
Objection, asked and answered.
No, I think that's a clarify for a thorough and sifting cross. Ms. Merchant.
I do not recall any other time that he mentioned that they were in a relationship. No.
When was this?
You may not.
When?
He was. Okay.
Let's get a year.
So you talked about this one time, and you said you don't know when it was though, correct?
That is correct.
Was it before Mr. Wade, before you got the contract in Fulton County? Let's start with that.
I do not recall.
Okay. And how did it come up?
Say again.
How did it come up?
I do not recall how it came up. It was in the back. I know where it occurred. In our offices in the back. I can't tell you what we were discussing prior to that.
So it's definitely not privileged. Because if it was part of his consultation, then it would be.
Did you receive an email from
likely
me on
recall
January
that.
6th with a motion attached?
I think I did. Yes. Yes. I know I received I don't know if the date is January 6th, but yes, I received that.
Okay.
Yes.
So you remember receiving that?
Yes.
It's the date.
Hmm. Agree, Southern.
And you reviewed it, and then you and I spoke about it. Do you recall that?
Did we speak over the phone or are you saying through a text?
That's what I'm asking you. If you
I
recall
can't
speaking-
remember whether it was text or phone or
But you recall us speaking, one way or another.
one way or another. Yes.
And where I was trying to confirm the facts in that filing.
I think I remember there was a line of about the accuracy of how much money that my office, the law office of Terrence Bradley, have received, and whether or not that was going to be in the motion or not.
There wasn't a discrepancy. I had kept that out. You asked me to step back in, correct?
Oh, for the love of God.
I recall you that may be accurate, yes.
She's so.
Because you thought it might be suspicious if you were left out of the motion.
No, I think we discussed that it should reflect the accuracy because the accuracy was that I received, I had a contract and received 74,000. And I think you had put in there that Mr. Campbell had received a certain amount, and then you also had put in there that Mr. Wade had received a certain amount, but there was not anything in there originally, and I said that it needed to be accurate. I needed to be accurate as far as that I had received 74,000. That's
Right.
correct.
Because you did not want anyone knowing that you had talked to me.
I think so too, Worcestershire.
Object as to relevance.
Be biased. Overruled.
I wanted you to be accurate as far as the accuracy of our message or your filing.
Okay, so that was your interest was in.
I agree with you on that.
I didn't reach out to you and say, send me a copy of your motion.
Right.
I didn't reach out to you to say that that I'm going to be in your motion
Right. I asked you to review it for accuracy.
for accuracy. And I just stated that it was inaccurate.
And the inaccuracy that you pointed out was the thing about or how much you had made.
That was the inaccuracy that I saw that jumped out, was the fact that I saw that I was left out when you had put the firm, the money was. I did not, when I responded to that, it was for that specific reason.
Okay. And I agreed I would put that back in, that section back in, and I did.
Correct.
I did put it back in and I sent it to you again.
I don't recall getting a second email from you, no.
But you were happy that I put it back in, or that I agreed to put it back in.
And object as to relevance.
Yeah, we need to get to more material aspects.
Seriously.
Uh,
Stop fixating on your
I'm
stupid prior
moving on,
conversations
I
with
promise.
him.
So you did ask me to put that back in.
Again,
Well,
asked and answered relevance.
well, he didn't answer that last question, so overruled.
You did, can you confirm you did ask me to put that back in for it to be accurate?
Yes, that's correct. I said that, yes.
Okay. And then I asked you if everything was accurate and you said, looks good. Correct?
I recall you asking that, but the looks good was applying to the accuracy of the 74,000. That's it.
So when you reviewed the motion and you specifically pointed out that one thing that you found inaccurate, you didn't point anything else out that you found inaccurate in that motion though, correct?
No, I did not.
And that motion alleged that their relationship began when Miss Willis was in municipal court.
If I can reread the motion, but I don't recall, but if that's what it says. But I did my saying that it looks good was when you put back in the 74,000 into your motion.
So she's trying to get him
That
to
wasn't what I
adopt
was asking. What I was
all of
asking
her
is,
statements
you
in the
didn't tell
motion
me that
as
there was
being
anything
true
else inaccurate in the motion.
by
though, right?
implication. That's why she's going through this line of
But I didn't
questioning.
state that anything was accurate other than the 74,000.
Now, when I told you that I had this motion that I was preparing, you asked me to send a rough draft.
No, that's incorrect.
May I approach, Judge?
You may.
Her objective here is to say everything she put in her motion, he recognizes being true, and he even reviewed it and critiqued some of it and said that's not true, didn't critique the rest of it. By implication, he's adopting all of her claims that the relationship was ongoing well before the Wade contract on November 1st, 2021. That's what she's trying to go through here now, in case you're curious, is confused by what she's doing based on her less than perfect questioning. To answer your question, I love having Southern Law on here. He's great. He's a very smart attorney. He's awesome. And I just find that with trials, I don't know. I find that no one knows when to talk. There's such limited time
We
to
had been
talk.
talking and you asked me to send you a rough
So-
draft and I told you, okay, but I didn't want it to be leaked before I filed it. Right?
That is correct. That is correct.
So you're the one that asked me to send a rough draft.
And the point to the rough draft question is to say he was
Yes, that's correct. Yeah,
he's
yes, that's
planning to
correct.
review it and make sure it's accurate.
On Saturday, January 6th.
This is a decent line of
And
questioning.
then you got an email from me with that rough draft at 10:25 that same day, correct?
Yes.
Precisely.
If you need to look at it, I can.
If it says 10:25, then I know you sent me an email.
While he's looking at it, I'm gonna object us to ask and answer. We've been through the fact that she sent him a copy of the motion, whether he specifically said rough draft or not.
Speaking
and then asked
objection.
about the accuracy, he's
Speaking
explained
objection.
his answer, and I've object to ask and answer. So
Understood, Mr. Vaughn. We're getting there. Overruled for now.
And then I responded when we were talking about that footnote that we were just talking about. I said, I took it
know
out,
who
but
it
I
is.
can add it back. And you said, yes, add it back. You remember that?
I answered that, yes.
And then I said, anything else, anything that isn't accurate? And you responded, looks good. You recall that?
Let me see the,
She's actually starting to corner him now
That were admitted.
to get him to adopt, to say that he adopted everything she said there as being accurate.
That refresh your mind?
it says looks good, but as I stated before, I was responding to you putting me back into the motion for receiving $74,000 in a contract.
This says, you said, yes, add it back. And then I said, anything else, anything that isn't accurate. And you responded, looks good. So you weren't responding to put it back in.
Your Honor, I'm gonna object.
I
This is
know.
not his motion. He wasn't the affiant of the motion or verified.
Overruled, Mr. Body.
Talking about his personal knowledge.
I've said
No personal knowledge.
twice,
Overruled, Mr. Body.
I've said twice that the looks accurate was, or I've said more than twice, was for the 74,000.
He is testifying like someone who's being leaned on. Like he's trying
Do
to
you remember telling
recant
me
anything that's
about,
helping.
Nathan and Fani coming to your office and spending time together at your office?
No, I mentioned, I do recall testifying on the 16th that she had come to our office.
And that was before she was elected as district attorney, correct?
I recall that that was when she was district attorney. Because I said that there was a meeting held at my office.
And who was at that meeting?
Now, I can't tell you that. I don't recall.
But you know, Miss Willis was there, Mr. Wade was there.
It was at our office. Actually, Miss Willis was there and there were other people there. Mr. Wade was not in that meeting. He was in the back. I wasn't even in that meeting.
There's so
Why did
many
she hold it at your office then?
I
better
have no
ways she
idea.
can get at this.
You also remember telling me about them spending time together at her law office before she took her job.
I don't recall. Do you? I don't recall. Do you have
Keep
something?
fixating on
to-
their prior
What I'm
conversations.
asking is, so let's back up a sec. So Ms. Willis rented a law office from the Evans firm, or Andrew Evans and another lawyer, I think Stacy Evans. You have knowledge of that, correct?
I'm gonna object to hearsay.
If,
Well,
How does he know the information? That would be the correct question.
okay. Ms. Merchant?
I don't really know even how to respond to that. Hearsay, I'm asking if he knew that she rented
Yeah,
offices.
he may have been there. He
Right.
may have seen a business card or something at some point. I think you can answer that.
I've never been to Miss Willis's office when she was in private practice. I've never dealt with where she rented. I didn't even know where her office was. So
Do you remember though, knowing that she rented an office
yes,
from the Evans?
yes,
You did know
that's,
that. Thank
that
you.
is correct. Yes.
Okay. And do you remember telling me that Mr. Wade and Miss Willis would rendezvous at that office?
I'm gonna object to, again, hearsay as to how he knows that information. He said he has no personal knowledge. And
He did
just-
not say he has no personal knowledge, Judge. He hasn't even answered it.
No, he said in general, he had no personal knowledge. So it's not been established the
His-
source of how he would know this because he said he's never been to her office.
All right. Ms. Merchant, if you, I know you're trying to impeach him by a prior inconsistent statement, but unless you can first back up and show why each statement is actually something that he had
You
knowledge
see,
of.
she's
I don't know if
striking
this is
out
gonna
so
be
many times that the judge is tired of
relevant.
standing up
And
for
Judge, I'm
her.
not even there yet, but again, that a speaking objection, and so now I would anticipate what our response is going to be next. I didn't ask anything that was objectionable, but these objections are coaching the witness. I asked if he had knowledge. That's it. I didn't ask, did someone say this to you? I didn't ask, what did this person tell you? I asked if he knew.
Well, no, you're asking if you had knowledge, and then you say of something specific. So
Once I get an answer to that, if he has knowledge, then I will follow up with where that knowledge came
all
from.
right, well, let's try again.
So my question is, do you have knowledge of them meeting at that office?
Objection, foundation.
Okay, all right, overruled.
Do you have knowledge of them meeting at that office?
I have no personal knowledge if that's what you're asking.
Because he got a
I didn't ask
speaking
that yet.
objection
I
got
asked
in.
if you have any knowledge.
Objection, that would be
Oh,
hearsay.
Overruled.
Not if it came from
We
Mr.
don't
Wade,
know where it
Judge.
came from. So he said, how do you know, Mr. Bradley?
How do you know?
Any knowledge that I would have received would have come from my client at the time.
Okay, so you had knowledge of this place that Miss Willis worked. What did you know about them meeting at that office?
Objection, hearsay.
It's not hearsay,
Overruled.
Judge.
How he knows it, and then you ask. the
He
next
may
question.
overruled it.
He's already asked the next question.
Can you repeat the question?
Yes. How do you have knowledge? What knowledge did, well, you just told us. You told us Mr. Wade told you. So tell us what Mr. Wade told you about Miss Willis and Mr. Wade meeting
Poorly
at
phrased.
the Evans office.
Objection, Your Honor, privilege. This clearly covers the time after December 2018 that would be covered by the privilege.
Yeah, overruled.
And that's why I told you they're going to be
You
objections.
recall the question, Mr.
privilege.
Bradley?
I do not.
You
He
re-asked
still
the
doesn't
question,
answer
Mr.
this
Bradley.
question.
What did you learn from Mr. Wade? Because we've clarified that's where you learned it from. About Mr. Wade and Miss Willis meeting at the Evans office together.
He doesn't want to answer.
I don't object to asked and answered. He's testified. that-
Shut
He
up.
hasn't answered. We haven't heard an answer.
He testified he had one conversation with Mr. Wade.
Sit
in the back of
down.
his
They're all
office.
terrified of this
And his
question.
answer may change, so
Tipping him
overruled.
off as to how to answer the question.
Shut up, Ashley.
I can't recall what the conversation was. I do recall knowing that that he would go down to the office or had been down to the office, but I can't tell you in what capacity or when or any of that. No,
Or what
They told
positions?
you that they had sex at that office, though, correct?
I don't recall him stating that. No,
You don't recall.
no.
So it's possible he did say that. You just don't remember one way or another?
I do not remember him saying that.
She doesn't know when to stop talking.
Do you recall that he had a garage door opener to either a house or a condo or something like that of Miss Willis's?
I've never seen a garage door
That's
opener.
not the question.
I've never been to Miss Willis's house. I've never been to, and I'm trying to explain, I've never been. So no, I do not have any personal knowledge of him having a garage door opener. Yes, ma'am.
I didn't ask if you had personal knowledge, like as in you saw it. Do you have any knowledge at all from Mr. Wade or any source that he had a garage door opener to access one of Miss Willis's residence?
And I'll object to any source as to hearsay.
All right, depends on the source. Overruled.
No, I'm not. No, I don't have any knowledge.
So when you told me that, did you just make it up?
Do you have something that shows that I told you that?
Yes, well, if we're going to go through all the texts we can, but so was that made up though?
But I'm gonna object because I
I don't recall him having,
Mr. Bradley, just a
I'm gonna
second.
object under 106 is the rule of completeness. I don't have that text message or any text messages that indicate that, Your Honor.
And I don't have, if it was a text, we had that conversation. I actually think it was when he was on speakerphone and Mr. Merchant was there, but I'm not sure. But I mean, if I'm asked to qualify exactly where that's from, I would give
Okay,
it.
so rule of completeness would be if you need to introduce other text to show the context. If you're saying you haven't seen a copy yet, then I think Ms. Merchant needs to do that before you can
And I don't
decide your
have,
next step.
and that's what I was asking him. If that was something he just remembers making up. If he doesn't, then that's fine. But
She referenced text messages and started to go into her packet of papers.
Sure.
That have text.
So you don't have a text message to that?
I would need some time to look through, and I don't remember if I have a text to that or if it was during a conversation. It was one of those.
All right, well,
And
he has now said that he has no knowledge, so on to your next question.
Did Mr. Wade tell you about the trips that he and Miss Willis took?
No,
You have any knowledge of the trips that he and Miss Willis took?
Objection, hearsay.
God.
Overruled.
I do now.
Okay, but you did not before this proceeding?
I did not know until you text that you found that in the deposition of his divorce. I mean, not deposition, but something from his divorce.
Okay, and when you responded, doesn't surprise me, they took many trips to Florida, Texas, California. Those are your words though, right?
I'm going to object as to relevance. He said he did not know, and he actually learned from Ms. Merchant the information.
He said he learned about certain trips from Miss Merchant.
Okay, you can tie it down, but
Thank you.
we'll
He said he
see.
had no information about any trip that Ms. Willis and Mr. Wade took. That he learned it all from Ms. Merchant. That was his testimony.
Sure.
Judge, I'm
Maybe the
allowed,
conclusion we reach. I think she can ask more than one question, though. All right, Ms. Merchant.
and if Judge, just so we can be clear, if he said more than one version, that's all relevant. We're allowed to talk about the different versions that he's told.
All right, I've overruled the
Thank
objection,
you.
Ms. Merchant.
Do you remember telling me that it didn't surprise you that they took the trips that I found in the divorce file because they took many trips to Florida, Texas, California? And then you told me that they took the trip to California when she moved her daughter there because she failed out of FAMU. Do you remember that?
I don't recall that, but if
Such a bad liar.
I don't recall.
Okay. Judge, may I approach? It's
You may.
It's in one of the ones I gave you.
Is it starting to ring a bell? He's saying, I don't recall if I told you that. That's not saying I don't recall whether or not that I remember that happening. She is so flailing all around. When he says that Wade brought her the contract, why not just say, well, was that surprising to you that he brought it? It's a contract between you and Willis. Why is he bringing it to you? Why would he be the messenger boy? What's the nature of their relationship? Did you find that odd? If
So
you
when
did,
that,
did you ask him, why are you giving this to me?
Just first, let me know if that refreshes your memory.
yes,
Okay.
yes.
So
But all this just
it's
goes
true that
over
you
her
told
head.
me that they took many trips to Florida, correct?
Per that, yes, but one of the messages is cut off, and you asked about some other trips, and I said, no, I didn't, I think. And that was specific to, at the top of that, it says, no, I didn't.
Yes.
And so that was to the trips that you asked me about. And I think before that, when you mentioned that you found all these trips, I think I said, oh, wow. And
You did not know about all the trips that were taken, and you qualified it. You said, no, I didn't. When did it happen? And then the next text, which I can get, or you can look at your phone or whatever refreshes your memory, you said was after you left, after the firm was dissolved, correct?
Subject to relevance.
Overruled.
It was after the firm, the trips that you said, no, you didn't know about. You told me those were after your firm had dissolved, correct?
I think you mentioned that they were after I left, maybe, or whenever you found them. And I said, no, I didn't know about those trips. So
So you believe I mentioned that it was after you left?
I'm quite sure you have the text message, and I will refresh my memory.
Is it
Yeah.
easier for you to refresh your memory with your own phone or with my printouts of screenshots?
Well, you have the printout, so I'll go.
Judge, the reason I'm asking is because I'm getting objections that I've cut things off, and it's just the nature of how you have to print out screenshots. So in order to avoid that, I'm happy for him to refresh his memory with his own phone, if that would be,
Well, I don't know if he's accepting your offer or not, so you're gonna.
would
have to
that be
proceed.
easier for you?
You can just provide the documents.
Okay.
I think he may be defending them because people say he's been threatened, like by his former fraternity brother or by other persons, that he's potentially facing SA allegations and potentially, who knows, criminal charges. So that's why people are speculating that he's feels inhibited from being free to talk about these sort of things, even if he hates Wade and Willis. I'm not saying he does hate them, but even if he were to hate them, that could be why he would do that.
I have
Yeah.
some water, Judge.
I think you need a lot of water. Can I please get some water?
Sorry, Judge, I'm just trying to pull out all of the messages that he may need.
All right. Well, I don't really see, some point we're reaching the cumulative point where we don't need to go through an entire 6-month text chain. You're making the point that he'd made some comments to you along the way that led you to believe he had more knowledge than today he's testifying that he had. And so if you've hit the high points of that, then I don't know what else we can cover that actually moves the needle.
Okay,
This is the
I'll
best
just-
you
I'll
can.
move on. So you told me that they took many trips to Florida. That refreshed your memory. Told me that. Was that based on your knowledge from Mr. Wade?
That would have been based on anything that my client would have told me. I didn't have personal knowledge of whether they went or not.
The trips to Texas. and
It's a very
you're
artful
one
way
to
of phrasing
Texas.
client told
Is
me.
that based on your knowledge?
It's
from
also
Mr.
your
Wade?
friend told you.
It would have been something that came from the client. I cannot tell you that I have any personal knowledge of any trip other than what
Maybe.
would have been said by the client.
You went on these trips. I'm asking if you have knowledge from Mr. Wade. You also typed to California. Was that something that you gained from knowledge from Mr. Wade?
It would have been from the client at this particular point. Yes, it would have been from the client.
And when you told me that the
Could
trip to
be.
California was to move her daughter out there, would that have been something you gained from Mr. Wade?
Thank you, Judge. Any knowledge that I have of any trip would have come from my client at the time.
She's so flailing.
You told us last week that Mr. Wade used your credit card one time. Do you know when that was?
I do not.
Relevance to why we're here today.
Well, I think this would be impeachment of Mr. Wade's testimony if Mr. Wade testified that he had never used anyone else's credit card
I
before.
object to ask him if he did because it was covered during the last hearing. He acknowledged that Mr. Wade used his credit card.
Judge, I
So,
asked when.
yes,
I didn't-
when, okay?
I didn't ask, did he? I asked, when did he?
Let's go there.
I do not have any dates of when Mr. Wade used my credit card. I testified that we used the card for business and that throughout the business, we would order paper or supplies or filing of depositions. I mean, the cost factor of cases is what I said, and that still applies today. Did he use my credit card? He did, but I can't tell you who he used that card, what the trip was for. I can't even tell you at this time where he went.
He used it for a trip.
Yeah, it was for a trip, but I can't tell you where, when, why, or anything
Maybe.
to that nature. Correct.
It's really getting in Sadow's way already.
Cash.
I never testified that he paid me back in cash. I said that he would either pay me back, I said I couldn't remember. I do not recall. Sometimes he would write checks, sometimes he would pay cash. And that still applies today, that I do not recall him paying me back cash, but I do recall him paying me back.
This was when you were still, before your partnership split up, correct?
It would have been before I left the firm, yes. He wouldn't have used my card after I left the firm.
So we can at least narrow down the dates to that.
Before I left the firm, yes.
Okay, great. And Mr. Wade gave you details about meeting Miss Willis in Hateville or East Point, as it was called.
That's incorrect.
He did not tell you about that.
He didn't give me details.
He did not tell you about meeting with Miss Willis at an East Point or Hateville apartment?
At this time, I don't recall. No, I don't recall.
Where did you get that information from then?
He's testified he doesn't recall if he even had that information.
I asked if he got it from Mr. Wade, and he says he doesn't recall. So then I asked where he got it from.
I do not recall where I got the information from.
Okay. And you and Mr. Wade were friends as well as business partners, correct?
We were friends in the sense of I've known him for years. Yes, we were friends.
And you definitely did not want to come and be a witness in this case, correct?
That is correct.
And it was after, and we talked about this earlier, that Gabe Banks called you and then Nathan Wade called one of your friends. It was after that that you hired Mr. Chopra to assist you in this matter, correct?
Objection. I would object to that if I were the lawyer.
Was it after that? So I hired Mr. Chopra and I hired Mr. Graham. Now, Mr. Graham is here, and when I received the subpoena, Mr. Graham was here at the last hearing, but he also had to go out of
Could be.
town, but he was present.
I don't think
Mr.
so.
Graham, I called,
10 contract?
and I had started getting
Maybe.
calls from media, and I told him to respond to the media, I think, and that was somewhere around whenever you subpoenaed me. So it was, I can't tell you that it was that instance of those calls for Mr. Chopra, but I had engaged Mr. Chopra and Mr. Graham at that time.
I'm going to ask the question again because I didn't get an answer to it. After you got the phone call from Gabe Banks and from Nathan Wade to your
I think it was before that, but however, I think it was before that is what I'm stating.
when you got from Gabe Banks, you called me immediately. Well, actually, you texted me and then you called me.
I didn't call you immediately, but yes, we did speak.
And you texted me about it as well.
That is correct.
And then we spoke after Mr. Wade called your friend, and we talked about that as well, correct?
That is correct.
And at that point, you didn't mention anything to me about being represented by Mr. Chopra.
But I didn't mention anything about Mr. Chopra or, that is correct.
Yes, that was only my question. Let's see. I'm gonna show you two more texts. They're in the ones.
All right, Ms. Merchant, we're going to do
Those are the
5 more
last
minutes.
two questions. Thank you.
3:05, I'm cutting you off.
Thank you.
Thank you, Judge. Thank you. We need Steve Sadow in here. Gosh.
May I approach? Show you a couple texts to refresh your memory, and then I want to ask you a few questions.
Spent an hour and 15 minutes. How closer are we now? How much do you feel we've learned over the last hour and a quarter through her questioning? And I know he's been evasive, and there's been tons of objections, but the nature of her questions, she's even been helped out by the judge here, and she's still struggling. So This is a kindness.
Are these supposed to go together?
No.
Oh, these are two separate dates?
Totally different dates.
Okay, all right.
But I have confidence in Steve Sadow. I think he'll do well.
So I know we talked about the other occasions when we had the text or just about footnote. But do you recall me asking you, do you think it started before she hired him? And you said absolutely. Do you recall that?
I see that in the text message, yes.
Okay. And do you also recall me asking you how they would react if they would attack me?
Stop on
And you
that.
said, no, they will deny it.
Your Honor, objection as to speculation as to how he thinks they will react.
I think it goes to the motivations of the witness overall.
And you told me that they will deny it.
That's written in there, yes.
I just want to, one last opportunity. You're an officer of the court, correct?
I am.
And you're under oath today.
I am.
Is there any of your testimony from today or the previous days that you want to correct?
That I want to correct?
Yes.
Oh my God.
No, I told you everything that I've answered everything that you asked.
Thank you. Oh, Judge, just so co-counsel and the state can have them, for the record, I can admit those few that I showed. That would be.
Well, they weren't ever tendered,
And
so it's
in
just
case-
for,
I didn't know if they wanted
Brian.
to use them, but I'll hold on to them.
if they need to be tendered at some point, then we can make them part of the record. All right.
Thank you so much, Ron. That's
Let me
pretty
turn it over to
funny.
Mr. Sadow.
I'm going to try that one time.
Thank you, Honor. I do have a few questions.
Go for
First
it.
thing I'd like to know is whether the court reporter has defense exhibits 26 and 27 from the last.
We have a different court reporter this time.
This
We
is
have
Steve
someone
Sadow.
else filling on such short notice.
Trump's
so I
lawyer.
can potentially send those to you if you need them.
Well, I think I have working copies, but I want to make sure that the witness has a copy to look at.
All right. We can try to work through that logistical challenge. This is, you said 26 and 27?
I believe that's correct. And 26, I think, is the same text messages that Ms. Merchant was just asking about. It was 2 pages. I stapled it together, and it is dated January the 5th of this year.
All right. I can print off a copy now, but why don't we start off with the questions that you have?
Okay, because
I think
that's
do
where I
it
want.
here.
That's where I'm going to start, but I'll see what I can do to work through it.
It's not going to work? Here, I'll lean on to you. Okay. All right, Mr. Sadow, why don't we start with your question, and we'll see if we actually need to get a copy of those exhibits in front of the witness.
All right. Mr. Bradley,
Yes, I'm here.
all of a sudden I've lost you on the screen.
Now we have you.
There we go. Well, you're on the Zoom. You're on YouTube, but you're not on the Zoom itself. But not that I can see.
I'm here. I can hear you.
No, I know. I think his visuals may be a little different. So hold tight, Mr. Sadow. We could try to correct that.
Yeah, he was on. He was on when Miss Merchant was asking questions.
We need
Able
to add
to
a,
see you and him.
I know, we need to add a spotlight to to the witness stand and a spotlight to Mr. Sadow, and we don't need all the other boxes.
Yeah, get rid of all them other
There we
freaking
go.
boxes.
Thank you very much.
Well,
Now we
hold
don't
tight,
see
Mr.
him.
Sadow. We need to add you as well.
Yeah. Some judgment there would be good too. Judge Sadow Terrence. And maybe
All right, now we're ready.
his counsel.
Thank you, sir. Mr. Bradley, you have referred to Mr. Wade as your client, correct?
Good.
Correct.
You understand that the court has ruled that communications that you had with Mr. Wade are not privileged, correct?
No, I'm aware that the court ruled that one specific dealing with the time frame of one specific conversation wasn't privileged.
Then I'm going to ask Your Honor, if it's that the limitation or
Excuse me. To clarify,
email-
I think, sure,
Sorry.
Mr. Sadow, you asked whether all communications with Mr. Wade, I think, were covered. That was not the extent of the ruling. The only ones that I deemed were not covered and that I'd asked about in the in-camera hearing, because those are the ones that were relevant, were any communications Mr. Wade made regarding the existence or non-existence of a romantic relationship with Ms. Willis.
Fine, thank you, Your Honor. I understand. So going back to this line of inquiry, when you say you don't have personal knowledge, what I want to ask you to start with is very simple. Did you have communications with Mr. Wade about the relationship between Mr. Wade and Ms. Willis? It's a simple yes and no.
Yes.
And is it your testimony that during the time you were representing him, which I understood started sometime in 2018, is that correct?
That's the time frame that I remember, yes.
Is it your testimony under oath that with regards to conversations with Mr. Wade about his relationship with Ms. Willis, that you only had one such conversation during the time you represented Mr. Wade?
One conversation of what? I apologize.
The only thing
broke up.
the only thing I'm asking about is that area that the court said is not privileged, which is the relationship between Mr. Wade and Ms. Willis. You've testified that during the time you represented Mr. Wade from 2018 on, that you only had one conversation with him in reference to the relationship between Ms. Willis and Mr. Wade. Is that correct?
Yeah, I think that's fairly accurate. Yes.
Okay, so out of the entire time, I'm talking about could be 2018, 2019, 2020, 2021. When did you stop representing Mr. Wade?
It was a few months after I left the firm.
All right, give me the approximate time.
I left maybe June, July of 2022, maybe.
Okay, so that would suggest that for, assuming it's 2018, 2019, 2020, 2021, and half of 2022, which is in the vicinity of 4 to 4.5 years, you're testifying under oath you had one conversation about a relationship between Mr. Wade and Ms. Willis. Is that correct?
I don't recall having any other conversation with Mr. Wade about him and Miss Willis.
Is it your testimony then that you don't remember any other conversation, or there wasn't any other conversation besides the one?
Good.
And object is to ask him to answer.
I think he's drilling down. I think that's a fair question overruled.
Good.
I don't recall. I would say it was the one, but I don't recall.
You testified that you did have communications with Mr. Wade about him visiting with Miss Willis at a condo or apartment, correct?
I don't think I testified that I had a conversation. I testified that any knowledge that I would have known anything about any condo would have come from that, but I don't recall a conversation about that. I do not recall a conversation about that.
Do you recall any other thing at this point in time under oath that would indicate when the relationship started between Mr. Wade and Miss Willis?
What
I
about
do
when
not know when the relationship started.
when you
between
filed
Mr.
divorce
Wade and
on
Ms.
November
Willis.
2nd, 20 the
Cannot
day?
recall that. I can't. Oh, I'm sorry. Go ahead.
I'm going to drill down on that now, okay?
Yes, sir.
Mr. Wade was hired as the special prosecutor on November 1st of 2021. You're aware of that, correct?
I have my contracts to show when I started. No one showed me the contract of when he started, but but if he has a contract for November 1st of 2021, then that's correct.
I'm going to I'm going to suggest to you that the record will reflect that the contract between Ms. Willis and Mr. Wade was November 1st of 2021.
Good.
Correct?
Day before he files for
I
divorce.
want you just to accept that, okay? Is it your testimony that you don't know under oath whether or not there was a relationship between Mr. Wade and Ms. Willis before the contract?
I do not recall any dates of when the relationship started. So whether you are pinpointing a date of when his contract started or not, I'm telling you, I did not recall
He filed for
any
divorce the next
specific
day.
date that he flat out said anything about a relationship with Miss Willis.
Okay. Now I want to go, based on what you've just said, let's go to what was Defense Exhibit 26. Okay? In Defense Exhibit 26, which I showed you last time, was 2 pages of text messages between you and Miss Merchant, correct?
Correct.
Now, the first page starts off by saying, Miss Merchant, like just date, don't hire him. Do you think it started before she hired him? You see that?
Yes, I see it. Yes.
And your response to that was absolutely, correct?
I'm going to object, asked and answered in cumulative.
All right. So, Mr. Sadow, I do think we went through a lot of these texts.
We didn't go through this whole one.
Just a second, Mr. Sadow. All right. I'm sorry, Mr. Sadow. Well, you said we didn't go through this particular one?
No, we stopped right there. I want to go.
No, I answered because
No,
this is the
there's no-
exact language that she just stated a few minutes ago. You can read it back
Okay, Mr.
in the
Sadow.
record.
Are you saying both of these 2 exhibits weren't already covered by Ms. Merchant?
It was not gone, this particular language was not gone into. I'm doing it based on the exhibit itself. Well, let's do it this way. I now move into evidence defense exhibit number 26.
All right, and I'd have to search through my notes, but does anyone recall that one actually been tendered in a minute already?
No, it was only presented to your honor for you to take back into camera ex parte to speak with Mr. Bradley and his counsel.
Okay, Ms. Merchant is indicating that it was admitted.
I thought Mr. Sadow admitted it, but I'm organizing.
She
putting it
sucks.
back in order.
Shut up. Leave
So
the room.
I think it might be easier if I just admit
It might be easier if you just stop talking.
right.
what we're all referring to.
All right, so Defense Exhibit 26 and 27 are being tendered.
Actually, only 26 at this time.
Excuse me. Okay, Defense Exhibit 6, any objection from the state?
26.
26.
I'm going to object as it relates to foundation and authentication. It was used to, during the last hearing for the purposes of refreshing his recollection. And it's my recollection is that it didn't refresh his recollection, but I would renew my objection as to asked and answered in cumulative.
Okay. As to foundation and authentication, I think Mr. Bradley has recognized them as texts that he sent and received. So I think I'd overrule on that basis any other objections to their admissibility from any other defense counsel, and seeing none. Defense Exhibit 26 is now admitted. Mr. Sadow.
Thank you. All right, let's continue. Now I'm publishing it. After you said the word absolutely, on your own, you said it started when she left the DA's office and was judge in South Fulton. They met at.
Check.
Yeah.
Asked and answered.
All right, understood, Mr. Body. I'm going to let Mr. Sadow have a few minutes on this, and we'll go from there. But
Judge, well, I'm sorry. I did answer this. I answered it for Ms.
understood.
Merchant. I stated that I was speculating. The judge, someone objected to the speculation.
All right.
But
we don't
this
need
was
to hear
the
your whole
exact same language.
All right, well, thank you
when
for
I
that
said
recap,
that I
Mr. Bradley. Mr. Sadow's
speculate.
asking the question in a slightly different manner, and I'm going to give him a little bit of leeway to do that. So,
Yeah,
Mr.
to
Sadow.
drill into your speculation.
All right, I hesitate to have to start back where I was, but after the word absolutely, you on your own said it started when she left the DA's office and was judge in South Fulton. They met at the municipal court CLE conference. That's what you said, correct?
That is correct.
Now, it's your testimony, at least so far, that when you on your own gave those two statements in the text, that you were merely speculating
What caused
and
you to
did not
speculate
have
that?
that knowledge from Mr. Wade. Is that your testimony under oath?
Yes, that's what I testified to. Yes, sir.
So you on your own came up with the whole notion that it started when she left the DA's office and was judge in South Fulton. That's, according to you, that's speculation on your part, correct?
Objection. Asked and
Overruled.
answered.
Answer the question, Mr. Bradley.
Yes, that's speculation on my part. Yes.
Right. It had nothing to do with what Mr. Wade had told you, correct?
I answered your question. I was speculating to the answer.
So you
That
must
is
have seen
correct.
something.
So maybe you can tell the court in your own words, why in the heck would you speculate in this text message and say that it started when she left the DA's office and was a judge in South Fulton? Why would you speculate and say that in a text?
Good.
I knew they had met at the municipal court conference.
How do you know that? I'll stop you right there. How did you know that?
I answered that at the last.
I'm
I
asking
knew
you
that.
now.
I knew
Sir,
that
I'm
because
asking you
when
ne- I'm asking you questions and you are in a situation where you get to give answers. I'm
Mhm.
asking you, how did you know that?
Well, you told me.
how did I know
Somebody
when they
told-
met?
Somebody told you that, right?
When they met?
Yeah.
Yes, correct.
Who told you?
Mr. Wade told me when they met.
So you had more than one conversation about the relationship between Mr. Wade and Miss Willis because he told you where he met her.
Good.
That's
Correct?
incorrect. Incorrect.
It's incorrect.
It's incorrect.
Let's go back
He-
to the exhibit. Why
Get 'em.
would you speculate that that's when they started the relationship? What would cause you to put that down as
Yes.
speculation?
I don't recall, but why I thought that it started at that time. But I do recall that he only met her, and I testified to that he met her at that conference, which was in 2019.
You knew that Ashley Merchant represented a defendant in this case when you were text messaging with her, correct?
Yes, I did. Yes.
And you knew that the reason she was asking you questions about Mr. Wade was because she was trying to show when the relationship began, correct?
No, that's not.
It's not. What's the
100%
beginning of the
correct.
text message?
He's doing a good job drilling. This is a good job
Yes,
of
but
pulling
what
him in.
messages were before this message, before
This
she
is
said
well
that?
done.
I can't answer that question because I don't have them. All I have is what's in front of you. And it
Yes.
says that she says, do you think it started before she hired him? So you knew as the counsel for a defendant in this case, that Miss Merchant was asking you specifically about the knowledge that you had regarding the timing of the relationship between Wade and Miss Willis, correct?
Not exactly.
I mean, based on this, yes, I see
And
what was asked.
And in response to that, you answered directly on your own what you now claim to be speculation, right?
That's correct.
So I ask you one more time before I move to the next part of this. Why would you speculate when she was asking you a direct question about when the relationship started?
I have no answer for that.
Except for the fact that you do in fact know when it started and you don't want to testify to that in court. That's
Overruled.
the best explanation, isn't it?
This is a completely
Overruled.
argumentative.
That's the true explanation, because you don't want to admit it in court, correct?
No, I have no direct knowledge of when the relationship started.
I'm not going to go back through that again. But if you didn't know, and you were asked specifically as this exhibit shows,
Mhm.
maybe you can explain why you wouldn't say, I don't know.
Is that a question? You're
Oh,
asking
yeah,
me a
it's
question to
definite-
answer?
Definite question.
State that again. I apologize.
If you're being asked, as we've just gone through with this text message from Miss Merchant,
Yes.
as the attorney for a co-defendant,
Yes.
and she's asking you about the relationship, and she's clearly asking you about the timing, why wouldn't you just have said in response, I don't know when it started?
I don't know why I didn't say I don't know.
Maybe, again, it's because you know what the truth is, and that's why you answered exactly the way you did in Defense Exhibit 26, correct?
No, I can't sit here and tell you that what you just stated was correct.
Right. What you want the court to believe, and you want the rest of us to believe, is that for some unknown reason, upon being asked a direct question about when the relationship started, you decided on your own to simply speculate and put it down in a text message, as opposed to putting down what you actually knew. That's what you want the court to believe, correct?
That was a lot. So can you break that down? I apologize. You're asking me, do I want the court to
To believe that instead of saying nothing, you decided on your own to speculate.
Random dates.
Yes, I speculated. Yes, I've stated that I speculated. Yes, sir.
Right. That's what you want the court to believe, correct?
That's correct.
Okay, now, then when you go to the next page of that, okay, you see it starts, the best that I can see, it starts in South Fulton. Is that what you have in front of you? Second page.
The second page that I have says, that's what I figured.
Okay, that may be cut off from the one that I have. I'm looking at.
Please ask him what led him to
my
have
opening
that
set
speculation
line
specifically.
says in South Fulton.
What
Is
did
that
you
on
see?
your
What did
second
he
page?
say?
No, so if you're going in order of the pages, no, neither page starts with South Fulton.
No, don't get caught up on whether it starts that way. Does the second page have a line in there that says in South Fulton?
Oh, yes, I apologize. So, yes.
That's fine.
Yes.
Just want to make sure that we're on the same page.
Yes.
Literally.
You say after in South Fulton, they met at the municipal court CLE conference, right?
Yes,
See that?
is good. Yes, that's correct.
And then Miss Merchant says, that's what I figured when he was married. Is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. You see, that's what she said, right?
No, I mean, so it says that at municipal court CLE, the only other thing here says, that's what I figured when he was married. There's no response for me on that day. And then there's another response. I guess a question that says, is this accurate?
Okay, that's what I just went over with you.
Okay, so
I don't know.
have
I don't know
anything in that. Is this accurate at all? I can show the court. It's just,
Okay.
it just says, is this accurate with the question mark? I don't have anything following that.
You don't have, after that, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship.
Yeah,
with
okay,
that-
I apologize. goes to the next page. I apologize.
No problem. Just want to make sure that
But no, I see that now. Yes.
I'm,
All right, so
I'm waiting
that's
for them to ask
what I just
this.
read is
Mhm.
exactly what Ms. Merchant said to you in the text, right?
Yes, that was in the text. Is it accurate upon further information? Yes, that's there.
And-
Yes.
Again, since you have told us that you were speculating when you gave the answer that
What
we went
is
over
it based
with
on? This
previously.
question. This
On this one, you don't say, I don't know.
question.
You simply correct her by saying no, municipal court, right?
Yes. So she asked, was it accurate? And I said it wasn't accurate. No, it wasn't accurate. It was municipal court.
Right. And when you said it wasn't accurate, it was municipal court, you didn't say, no, that's not accurate. They didn't start a romantic relationship at that time, correct?
No, but I was referring to the municipal court. No, it wasn't accurate as it applied to the, I was answering the no municipal court, meaning when she said, is that accurate? It was to the municipal court and not magistrate court.
Okay. But you didn't say that the rest of what she asked you was accurate. You didn't say, no, that's inaccurate. That's not true. That's not accurate. You simply said the only thing that wasn't accurate, municipal court should be there instead of magistrate, right?
So I was answering the question of, it was a compound question.
Can you
And
add-
I was answering the question of, she wrote magistrate court and I said, no, municipal court.
Right, but it's not compound.
He seems
It's
very
one
afraid.
Statement upon
Mr. Sadow.
information. I'm sorry.
No, that's okay. I know the feedback and the delay is complicates things, but I think you've adequately made your point here. And I don't think we need to belabor it much longer. Let's move on to the next issue.
Thank you, Your Honor. Mr. Bradley, prior to coming into court today, did you and your lawyer meet with anyone from the district attorney's office?
No. I mean, no, not that I know, I'm aware of, no.
Have you
I
had
did not
any?
meet to anyone.
I'm sorry. I
I
cut
did
you
not
off.
meet with anyone outside of my attorneys.
Did you have any conversation? Not
I
meeting.
did not.
Conversation.
I did not.
So you have not spoken, if I understand you correctly, prior to coming into court today, you've not spoken with the prosecutors,
No,
right?
I've not spoken to the prosecutors. I've not spoken to defense.
Have you spoken to Mr. Wade?
No,
So as far as just getting into the courtroom today, there's been no contact or conversation in it with any of the parties we just went over, right?
there has not been any contact with defense or the state at all.
Please ask him this
I
question.
think I have basically just one or two more questions. Why would you see the need to speculate when you were texting with Miss Merchant?
You asked that already.
I think we did cover that one, Mr. Sadow.
Ask what it was based on.
I think that
He didn't-
exact question was already put.
He
to
didn't
him.
speculate they were mortal enemies. Why didn't he speculate that?
What would be the next one?
Or tie it into the timing of the divorce filing, not the
Trying to
date
look-
that he
let's
signed
go
the
to
thing.
27.
When you filed for divorce, did you know he was in a relationship with Fani Willis?
Defense Exhibit 27. Do you have that?
It was
now,
the
sir?
day
I
after
do,
he
sir.
got hired.
All right. Would you look at it and tell me whether or not the Defense Exhibit 27 appears to be accurate? Because I want to seek to introduce it into evidence. It consists of an email to you from Ms. Merchant and a text response from you, correct?
But the text response was not in response. So yes, it does consist of the email and a text response. I'm not saying that the text response applies to the entire email that was sent.
All I've asked you right now is, is
Yes,
the email and the text, are those accurate in the interaction that makes up Defense Exhibit 27?
As it applies to the stapling of the email and the stapling of a text message chain, yes, that is defendant's exhibit 27. This is, it's accurate.
Okay, I would move defense exhibit 27 in. I believe it was treated the same way as 26 last time, Your Honor.
Same objections, Mr. Abadi?
Yes, Judge.
All right, overruled. Any other objections from defense counsel? Seeing none, defense exhibit 27 is admitted.
And, Your
Anything
Honor, I
else,
don't
Mr.
know.
Sadow?
Yeah, I don't know whether you'll find this objectionable or not. I'll ask it, and obviously.
All right.
Mr. Bradley, you realize that if you were to testify under oath, that you knew from
It's not gonna
Mr.
be
Wade
powerful.
that the relationship between him and Miss Willis existed before the contract in November 1st of 2021, that if you testified that you knew that from Mr. Wade, that would show that both Miss Willis and Mr. Wade had lied under oath. You know that, don't you?
Yeah,
I'm gonna object.
I think that's going to call for an opinion on the credibility of another testifying witness. So I don't think that would be an appropriate question.
Then that's all I have, Your Honor.
Thank you, Mr. Sadow. Mr. Stockton,
Just briefly, Judge.
we'll see.
Mr. Bradley,
You
do I
can't
understand
give
from
me
your
the
prior
mic.
testimony that Ms. Merchant sent you a motion to review prior to her filing it?
Objection. Calls for cumulative answers.
Right. I'm going to give him
active
just a little bit. All right, Mr. Stockton, maybe this is going somewhere else.
Did Mrs. Merchant send you a motion prior to January 8th of 2024 for you to review?
That is correct.
And did you in fact review that motion?
That is correct.
And did you indicate to Ms. Merchant that the contents of that motion seemed okay to you?
Well, so you're referring to exhibit 27, which as I stated a few minutes ago, one is an email, one is a text chain. So in the text chain, when I never responded to the email, I never responded looks good or anything to the email that was sent to me. However, in the text chain, what you all are trying to merge together is the fact that I was asked about the contract, and that contract was $74,000, and me being added back to that. So when I said, and I think before that in that text, it referred to me being added back, and at that time I said yes, looks good.
And you're aware and you recall that when Ms. Merchant presented you with that motion, she asked you not to disclose it to anyone until she filed it. Is that correct?
We are covering, I think, the last 5 or 6 questions. We've covered ground. Let's get to that ultimate point.
I'm trying to get there, Judge, I promise you.
Okay.
Repeat the question, I'm sorry.
Lord
She
Bradley.
asked you not to disclose that
Like a
motion to
dentist.
anybody until she filed it, correct?
I think so. I think that was in the text message, yes.
And you knew in fact it was her intention to file that motion, correct?
The actual motion that she, that was sent,
Yes.
I knew that she was going to file a motion, yes. I do not think that that was the final draft, or it could have been.
But the
that she
factual
was working
assertions were based
it,
on what you
but
told her.
Yes, I knew that she was going to file some motion, yes.
And you knew that she presented that motion to you for your review so that she could make sure it was accurate, correct?
Your Honor, I'm gonna object. All this is asked and answered in cumulative. We have-
All right, noted. I think Mr. Stockton's getting to the next point. So why don't we just ask that one?
Is that correct?
Did you
Why
know
don't
that?
we
I thought
why don't we
you,
combine that with the next question, so we're not having to lay bit by bit every single time.
Mr. Bradley, you knew that Mrs. Merchant was relying on your review to ensure the accuracy of that motion prior to filing it, correct?
Speculation as to what he knew that Miss Merchant knew.
No,
gonna do.
I'd overrule that. Mr. Bradley?
no, so once again, I was excluded from the footnote of that motion. And my review
What does
of
that
it,
mean, a footnote
and
of
I
the
said,
motion?
hey, you need to add me back to the footnote because I did have a contract and I did receive 74,000.
If I may
That's it.
help you out,
That's not relevant to the
let's
question.
talk just about that part of the motion that deals with the relationship between the District Attorney Willis
Mhm.
and Mr. Wade.
Mhm.
When you reviewed that, you knew that that Ms.
No.
Merchant,
No, I did not know that she was relying on me for any relying on me for any accuracy other than what was put in there
if there
about the
was,
74,000.
Mr. Bradley, if there was something patently false in that motion, you would have told Ms. Merchant, wouldn't you?
I can't say that I would or wouldn't have. I don't know what I would have told Ms. Merchant.
If there was something patently speculative, you would have told Ms. Merchant, wouldn't you?
I don't know what I would have told Ms. Merchant. She asked me, was it accurate? We were discussing the 74,000 that was left out.
That's
Again, if I may direct you just to that
That's such a
portion
lie.
dealing with her.
That's such a
the
lie. Such an
Relationship
obvious lie.
between Mrs. Willis and Mr. Wade.
400 different things he told her, and all of a sudden, when
You
it comes to the
didn't-
motion,
you
he's
didn't
only
tell her
talking about
that
the
there was
74,000. No other
anything patently
issues.
false in that
What an
because you didn't
obvious
see
lie.
anything patently false in that motion as it relates to the relationship.
Repeat your question. I'm so sorry.
You did not inform Mrs. Merchant that there was anything patently false in that motion that you were presented with
Yeah.
as it concerns
He's
the
testifying like a
relationship
scared man.
because you did not see anything that was patently false, correct?
Objection asked and answered cumulative.
All right, next question, Mr. Stockton. Sustained.
And you didn't see anything that was speculative in there
All right.
either, did you?
Asked and answered
I
cumulative.
know, sustained, Mr. Stockton.
I just want to ask you one more question. I'm coming at from the other way that
No.
Mr. Sadow did.
Not with
Did
him.
anybody from the district attorney's office or any witnesses in this case contact you about Ms. Merchant's motion from January the 8th of 2004 until today?
Did anyone contact me about her motion?
Yes, from the district attorney's office or any witnesses or anybody else involved with the case besides the defense?
Other than the only personal call that I had was with Gabe Banks. I never spoke to anyone else, and to my knowledge, he's not a part of this, so.
That's all I got, Judge.
Thank you, Mr. Stockton.
Please.
Mr. Durham, if you're still with us.
Please,
question, John.
somebody ask
Thank you,
this
sir. Mr.
question.
McDougal.
And please
Good
also
afternoon,
ask
Mr. Bradley.
if he knew when he filed for divorce that they were in a
You
relationship.
have certain information about the relationship between Mr. Wade and Ms. Willis that is not privileged, correct?
Well,
Yes.
that was my determination, so I think he disagrees with it. So what we're going to say his opinion's a little irrelevant on that point.
Do you understand that the court has ruled?
Yes, he
that
understands
certain
that.
information
Stop
that
it.
You have
Oh my God,
about the
stupid questions.
relationship between Ms. Willis and Mr. Wade is not privileged.
I have the court's ruling, as I understood it, and as my lawyers and I understood it, of the privilege not existing was based off of a conversation that was had in my office, in the back of my office, which was confidential, with Mr. Wade and I.
Tell us
That's
more
what
about that.
was asked of me on yesterday, and that's what the ruling, to my knowledge, unless I'm being corrected here now and saying that it's more, it was that particular piece that the judge said did not have privilege.
And have you testified already today to the sum total of your knowledge of the relationship that is outside the scope of the privilege according to the court's ruling?
Can you ask that again? I'm sorry, I didn't understand it.
Referring to
Terrible
what you
question.
understand to be the information that is not privileged,
He's not going to answer.
have you
that. He's gonna-
testified
He's
to
going to
the
say
sum
yes. He always.
total of that information?
I think I have, yes. I think I've testified to that, yes.
All right, sir. That's my questions.
Thank you,
Thanks.
Mr. McDougal.
Terrible. Oh my God.
Mr. Rice.
Please,
Mr.
somebody.
Bradley, at least as of February 15th, when you first testified, you said that you still considered yourself a friend with Mr. Wade, correct?
I think I said that, yes. I think I did, yes.
And you've been friends with Mr. Wade for over 10 years, correct?
That would have been fairly accurate, yes.
And you recall communicating with Ms. Merchant about this case and about Mr. Wade and Ms. Willis's relationship, correct?
I'm gonna object as to asked and answered and cumulative by all three of the previous.
Sure.
Overruled.
We don't have to lay that foundation. Why don't we combine it with the next question where you've got a new point to make?
Mr. Bradley, when you communicated with Ms. Merchant, did you tell her any lies about Mr. Wade and Ms. Willis's relationship?
That's a good question.
Did I lie to Miss?
Yes. Yes or no?
That's a
I mean-
simple question, Mr. Bradley. You're a lawyer. Did you lie to Ms. Merchant when you told her facts about Mr. Wade and Ms. Willis's relationship?
Yes or no? Yes or no?
Not that I recall. I don't recall.
There we go. Now we're getting somewhere.
I mentioned earlier that I speculated on some things. I've testified to what I did know. So I can't recall whether or not no.
Mr. Bradley, speculation is kind of a weaselly lawyer word. Let's speak truth here.
I'm gonna
You're under
object
oath.
to argumentative at this point, Your Honor. It's not asking relevant questions.
Mr.
Let's
Bradley,
find a question, Mr. Rice.
Mr. Bradley, when you were communicating different details of the relationship between Miss Willis and Mr. Wade to Mrs. Merchant, did you lie to her about any of those details?
What was the
Asked and answered twice.
I don't think he's answered it yet.
I don't recall ever whether any of it was a lie or not
Well,
this time. So
at the time you were communicating with Miss Merchant, you were still friends with Mr. Wade, correct?
yes,
And at the time you were communicating with Miss Merchant, you knew that she was talking to you in her role and capacity as an attorney in this case, correct?
correct.
And you knew that she was going to use that information to somehow benefit and file a motion, benefit her client, correct?
Object as to
I did not know that.
Okay,
So I did not. Oh, I'm sorry.
So as an attorney yourself, you are testifying
you
here
saw
under
her
oath.
motion and didn't
You
know what
had
it was?
no idea what Miss Merchant was going to do
Really?
with all the details that you were giving her about Wade and Willis's relationship.
So at the time, no, I did not. I knew that Miss Merchant was gathering information. That is correct.
And did you lie to her when you told her that the relationship began
All right.
before 2020?
I don't think we need to drill into specifics. He's covered it at a high level. I don't think we're going to get much out of this.
Mr. Bradley, isn't it true the only thing that has really changed? Well, you were speaking to Miss Merchant, whether by text or by telephone. You never said to her that I don't remember or that I'm speculating, correct?
I don't recall.
Well, you've looked through a whole lot of text messages. Do you remember ever seeing any communication from you that said, I don't remember?
That's a good question.
Yeah, through the messages that, I don't have all the messages in front of me, but no, I don't recall if I ever said, I don't remember.
Do you recall
don't
sending
recall
any
if I don't
text
remember.
messages where you replied to her or gave her details where you said, I am speculating about this detail?
No, I never used the word, speculating, no.
And the only
That's a good
thing that's
question.
changed between then and now is that phone call from Nathan Wade's friend, Gabe Banks, correct?
Gabe Banks. Gabe Banks.
No, well, Gabe was my friend, and I actually stated that the first day that I was here was that I've known Gabe for a few years, and that we were not were, but we are fraternity brothers, and so I never said that that anything changed behind Gabe Banks.
So you never told Miss Merchant that you were worried that they were threatening you?
Objection asked and answered when he was asked this on February 16th and today.
Mr. Rice, we've covered this.
And just to be clear, you didn't attend college with Mr. Banks, did you?
I did not attend college with Mr. Banks.
When you referred to him as your fraternity brother, y'all just both happened to have pledged the same fraternity, different colleges, different chapters.
Well, that's what we consider fraternity brothers, yes, sir.
And
He just called you out.
as a normal course of your relationships with your friends, do you pass on lies about your friends?
Have I passed on a lie about a friend? Is that what you're asking?
Is that something you normally do, Mr. Bradley? Do you tell lies about your friends?
I like this question. I like
Have
that.
I told lies about friends? I could have, I don't know.
Do you tell lies about your friends about a case of national importance?
Objection as to
All right, overruled.
Objection, please. I can't think
I
of a
could
good
have, I don't know.
Mr. Bradley, I notice you're not looking at me.
I'm looking at you on the screen only because I was accused of, and I did the same thing to Mr. Sadow when he was on the
What's
screen.
the next question, Mr. Rice?
No further questions, Judge. I think it's clear.
Thank you, sir. Mr. Gillum.
Good afternoon, Mr. Bradley. A few questions. A lot of folks have taken up the questions that I wanted to ask, but I've got a few left here.
We'll see.
We'll see. You said Mr. Bradley, you said you didn't know what Ms. Merchant was going to be doing with the motion that she sent you. You remember that testimony a few minutes ago?
I think I said I didn't know that. I knew that she was gathering information, yes.
Well, let's look at the title of the motion that she sent you. Do you remember
That was
reading?
sent on the 6th.
Excuse me, do you remember reading the defendant Michael Roman's motion to dismiss grand jury indictment as fatally defective and motion to disqualify the district attorney, her office, and the special prosecutor from further prosecuting this matter? Do you remember seeing that in the draft that you read and reviewed?
Yes.
So when you tell this court that you didn't know what she was up or what she was going to do, she kind of gave you a hint, didn't she, in the title of the motion that she
Nice.
sent for you to read? Didn't she? Yes or no?
I read the title of what the motion was.
There wasn't anything in the title that threw you off. Pretty straightforward speaking title, isn't it?
Correct.
So you knew that what she wanted was information from you so that she could then file a motion to dismiss the grand jury indictment, to motion to disqualify the district attorney and her office and the special prosecutor from further prosecuting the matter, right?
object to speculation.
You knew that, didn't you?
Overruled.
Ridiculous objection.
Yes or no?
When she sent that motion, yes.
Okay. And you knew that the special prosecutor that to whom she was referring in that motion was Mr. Wade, correct? You knew that
Yes.
because you read the motion. You said you reviewed it, correct?
Yes.
And we're not going to go over all of the, number one, because we don't have time, and number two, the court wouldn't let me. But but there are a few things that I do want to ask you about in that response, in that aspect. Now, in that motion, that you said you reviewed on page 6 of that motion. Well, on page 5, it starts off with, how do we know this? And there's a question mark.
All right. Yeah, Mr. Gillen, I can appreciate what you're doing. I think that's something you can do at argument. He's said as a whole that he got the motion and he's had his response as to his opinion of how he handled it. I don't see that, again, this really being necessary to go through it line by line of what.
Well,
he reviewed.
a little indulgence, Your Honor. I'm not going to go, this isn't going to be a 40-minute death march through the motion. I would like to ask about a few bullet points that capture under this, and then I'll move on. But I would ask the court's indulgence in that respect.
Again, I think we've covered it, and I think that you'll be able to argue that this was in that motion and that he had a chance to review it, and he never objected to anything in there or raised it. So
That's a problem, and always ending up last.
it very much is. And next time, I'll reshuffle the order.
Well, we did earlier with Mr. Wade, and then
I hear you.
that was kind enough, and then
Ask
the court
about
said
the
we had to
basis
go
of
on.
his
to draw straws.
speculation.
There we go.
Jesus,
I'll go with that.
please,
All right, anything
Thank you, Your
else?
Honor.
it's
That's
not
all I have.
happening.
Okay, we had Mr. Kucherov potentially still on Zoom.
Yes, Your Honor, and I have just a few questions.
All right, could we add a spotlight to Mr. Kucherov? I'll let you know when we're able to proceed.
All right.
Judge,
Good.
before he starts, can I take a 5-minute restroom? It's been
Absolutely.
2 hours.
Yeah, we've been going 2 hours, so let's come back at 4 o'clock. I'll also note for the record that we received
I'll try to get Chris
notification from
Kucherov's
Mr.
number.
Cromwell on
Let
behalf
me
of
see if
Ms.
I get his number
Latham,
here.
and he said he was waiving her presence. And I don't know if he later
Let me see if
decided
I
to
get
join
his
us by Zoom,
number.
but
If I could text him,
I don't
say,
think he
please, for the
was
love of God, ask about the basis
electing
of his speculation.
to log in. So after Mr.
I'll hit him on X.
Kucherov, just in terms of timing, Mr. Abadi, do you have any expectation of how long your, if any, questioning would last?
I don't imagine my questioning will be very long.
Okay, well, let's get back in at 4 o'clock. Mr. Bradley, you can just step out. Jury room.
I'm trying to see if I can find him on X. I can tag him. I need to see if maybe I can reach one of these attorneys by social media.
I want to say,
Oh, yeah.
They make those style moves.
I know. I love reading that.
I like the new haircut, man.
Thanks, man. I actually. Good.
I'll get one for you.
Sure, Chuck.
Yeah.
Damn,
yeah.
I'm at the following pro on X if you're there.
So that you can, yeah.
If you're not following me, at the
David
following
Schaefer.
pro. You also should be following me on Locals, which is goodlogic.locals.com. Goodlogic.locals.com. If you can please, I'll just mute that while we play that there. I'm going to run through a couple of your comments here. It doesn't matter whether it was based on conversation with Wade. It could be that he saw things. I just want to know, how did you come to that speculation? It's very simple. It's a really simple thing. You asked that question earlier. I kept pulling up when you asked that, Anna. Oh no, this is not it. That was a different question you asked. You said, why aren't they asked what the speculation is based on? There are a few questions that I want to take note of here. Let me just get to this real. It wasn't asked why. What I'm saying is this. When you form a speculation like that, you're saying it was asked multiple times. No. What did you see? What did he say that led you to come to that speculation? That's not, did you see something? He didn't come up with He didn't come up with, he didn't speculate that they hated each other. He didn't speculate that they were getting married. He speculated specifically that they were dating at that time. You also could ask about, he also should be asking about, why the heck is he bringing you the contract? What does that, was that surprising to you that he brought you your taint contract from Fani Willis? Do you think that he played a specific role in obtaining that contract for you? There's so much you can drill into, like how the more nitty gritty, rather than just allowing him just say, I don't remember. So how did you end up getting this contract with her, if not for the fact that he was pitching for you? Why is he the guy bringing it instead of her talking to you directly? All these things basically lay into the fact that it's like she's trying to find ways to basically wring money out of Fulton County to give it to Nathan Wade and or his firm, which is going to also get money to Nathan Wade. So isn't it weird? I'll tell you something. It's a very weird thing. What is he? Is he their messenger? Why is she dealing directly with him? What's the nature of the relationship between them? Did you think that was odd? Or did you expect that to happen? Did you expect that he would bring it to you? Or did you think that she would deal with you directly? And if you thought it was normal, you thought it was unsurprising, what led you to believe that that would be the way it would happen, as opposed to most contracts, I'm sure you signed with people directly rather than just going through a go-between. All of these things lead to like reflecting on the nature of the relationship between Wade and Willis long before April of 2022. Also, when you file for divorce, were you aware that they were in a relationship at that point in time? He signs his contract with Fani on November 1, 2021, and the very next day he files for divorce. When you file for divorce, were you aware of a relationship between Fani and Nathan? That likely would have come up during the course of conversation, right? When you were questioning him about his divorce and what you're going to be filing, did you ask him whether he was involved in with any women at that time? Also, none of them nailed down when the firm was first started, when it ended, how long, when you're sitting there in the office, like at what point in time, and he's telling you about it in the back room of the office, what is the latest period of time that could be? I mean, and I think he ended up saying it was in June of 2022. But like, what were you talking about beforehand? Talk more about that conversation, which is something that the judge clearly has said that he can talk about. I was very, very frustrated here. The entire time, the fixation kept being on trying to tie him into the text conversations with Ashley Merchant, the filings between that Ashley Merchant made and his review of them. It's too much is tied on that rather than just trying to. And I know he's going to try and be evasive. I get it. I understand that he's being as evasive as possible, and I'm confident the judge sees his evasiveness and recognizes it for what it is. So, and he's the ultimate finder of fact here. But still, obviously, it's far more powerful if you get something on the record, which is more concrete. And if you can basically force him to say, the reason I came to speculation is because they were always joking around together. Something like that. He called her all the time. You know that they spoke 12,000 times during that year. How often did you see them on the phone with each other? Did you ever see his phone? Reports of, 2,000 phone calls, 12,000 text messages. Did he ever talk to you about any text message he ever sent her? Ever? About anything? There's just so many different ways that they could have tried to skin this cat. And I felt as if they all got locked into that Ashley Merchant path of like, let's go through my text conversation with you. No one cares about her text conversation. He was asked blatantly, why did you speculate that? He said, I don't know why. It was a fast back and forth. Judge told him to move on when he started drilling. It was early with Trump lawyer. I don't think I respectfully disagree with you. I don't think she asked that specifically. Not why were you speculating? There's a difference between saying, why were you speculating, which that I heard a lot of questions about, versus what led you to come to this conclusion. It's not like what made you decide that I want to start speculating. It's like when you're speculating, your speculation is always rooted in something you saw beforehand. That's the point. And that's what you want to dig into. It's not. And this is where I think perhaps there's some confusion. Maybe I'm having a similar confusion with you that they seem to be having in this courtroom. It's not why did you start engaging in this thing of speculating that Sadow asked about, that several of the attorneys asked about. I'm saying once you're engaging in speculation, your speculation led to conclusion X. That speculation is based on certain things you saw. I want to know about those things that he saw that led to a concluding speculation of, oh, okay. It's almost like, okay, if you see someone, the old classic thing that they talk about in law school, you see someone walk in with a wet umbrella and a wet raincoat, you speculate, you come to a reasonable conclusion, it's raining outside, right? That's speculation. He says, I don't know that it was raining. This is essentially what's happening here. He's like, I don't know that it was raining. I didn't see it was raining. He didn't tell me it was raining. Well, you know what? There's other things that are happening there. He's sitting there giggling, saying, wow, Fani's so funny. Maybe stuff like that. I don't know. Maybe he shared selfies. Maybe he showed Terrence selfies of Fani. I don't know. But there's got to be reasons that made him think, yeah, I think they're going out. And they never drilled into that. That's what led to his speculation that they were dating. And those are the details which help lead to conclusions for the court that the court ultimately would reach the same speculation that he reached, assuming he really was speculating. I don't know that he was speculating. I think he's lying. I think he's full of crap when he says he was speculating. But if we want to pretend for a moment that he was speculating, that speculation would be like, oh, yeah, you know what? He's showing me selfies where she's dressed in ways that few district attorneys ever dress. Things like that.
Still with us?
I am, Your Honor.
All right, then let's go back on the record. We have Mr. Bradley here, and everyone else is here as well. You may proceed.
That's exactly what I asked, yeah.
Mr. Bradley, did you use any documents to prepare for your testimony today?
No, I did not.
When was the last time you spoke with Gabe Banks?
Oh, God.
The day that I don't have the date, but it was the date of whenever the phone call happened.
I'm not going to admit I'm being threatened.
You know his wife, Kyra Banks, works for the DA's office, right?
And his cousin,
Yes,
Tyra Banks, is a member of the Screen
When was the
Actors
last time you spoke to Mr. Wade?
I'm spoken to Mr. Wade personally in 2 years, actually, when I left the firm.
Miss Willis?
I never, my interaction with Miss Willis was never where I would pick up the phone and talk to her, or that she would, or anything like that.
So you didn't hang out with Miss Willis? You didn't have a personal relationship with her?
No, I never had a personal relationship. I mentioned before that I went to a dinner that was after she was elected. That was at a steakhouse, but it was some 75 to 100 people there.
So you knew of her, you just didn't have a business relationship or a personal relationship with her, or at least a close one.
I knew of her from she was in the DA's office and I had criminal cases, but I did not personally know her, no.
And not having known her, not really hanging out with her, you've got a contract from her office.
I'm gonna just object as to cumulative asked and answered throughout the multiple.
All right, Mr. Sheriff, I think we covered this ground on the 16th about the contracts. Do you have are you going somewhere else with this?
I am, Judge. If you give me a little latitude, I'll tell you.
All right. Okay, you may proceed.
You got a contract from the office, not knowing or having a good relationship or a good working business relationship with Miss Willis.
That's correct.
That's because Nathan Wade steered that contract to you.
I don't know how it came about, but it was presented to me.
This is getting to where I was talking
at the
about.
office about the contract, correct?
Who presented it to you, Mr. Wade?
Yes.
And he owed you money, you said at one point.
Say that again?
I think you said he owed you money at one point.
I don't recall saying that he owes me money.
Did he owe you money at one point?
Not that I recall saying that Mr. Wade owes me or owed me money. I don't recall ever saying that.
I didn't ask whether you ever said that. I said,
Sorry.
did he owe you or did he owe you money in the past?
No, he didn't owe me money.
And so he steered this contract to you, to your office, and you weren't really talking to him? You hadn't talked to him for 2 years?
The contract was in 2021. I didn't leave until 2022.
So you didn't talk with him that whole time?
I left in 2022. I haven't really spoke to him since 2022 is what I stated. When I left June of 2022, around June, August dates of 2022.
Other than one last question, other than your attorney, who did you speak with today about giving testimony in this
Who's
case
gonna say
today?
nobody?
I spoke to my attorneys, Charles Graham and BC Chopra.
I have nothing further, Your Honor.
All right. And again, I'll just double check to make sure. Did Mr. Cromwell ever join us by Zoom? Do we?
I should log in as Cromwell.
Okay.
He did email me saying.
I'm
he has
Cromwell.
no questions. It appears that all relevant questions were asked.
All right, thank you. So just for the record, Mr. Cromwell has been apparently watching the proceeding. He had waived his client's presence and didn't have any other questions.
That's not a
So we're turning it
gamble.
over to Mr. Abadi.
And I have no questions.
All right. Mr. Bradley, you can step down. Thank you, sir.
Judge, you want these exhibits?
Yeah, I'll take this one. Hang on.
May I
All
be
right.
excused?
That's right.
I have a follow-up based on some questions from counsel, and it's just about the text.
And what, just by way of proffer, what about the text?
Just to admit, so when other people asked about the text, some of them weren't in the record today, so I organized them. They're the ones that have been talked about today, so I just organized them. I just wanted, for point of reference, to have them. That's
Okay.
it.
Okay. And do we need Mr. Bradley for that?
I don't believe so, but
Have you marked them?
yes,
Have you showed them to the state?
I gave a copy to the state, but so these are.
Mr. Bradley, just hang on just for 1 second,
I
just to
know.
make sure.
I'll give you all of them. So
Admitting all of them? Or not?
you can, you must. You can start talking if you want. I don't want to object.
And authenticate them, so I can.
And while he's looking at that, Mr. Bradley handed me Defense Exhibit 23, 24, 25.
Judge, I didn't realize that they were
This-
in my folder.
Oh, is that from the hearing?
That
From on
was
Friday?
here, so-
All right, well, thanks for returning those.
Fine. You got that out. The reason I put those in is because you
Let
were,
me make sure.
As long as you admit it.
because of your objections, front part and the back part of this. You have an objection to any of them, you can tell me, or you can admit.
Okay, so I've got 23, 24, 25.
No, the difference between
Anything else in your
speculation and
binder?
gamble is it's not a roll of the dice. It's always rooted
Good.
on something.
Okay, and have we come to any conclusions on, what, I'm sorry, how did you mark it?
I think we're up to 39. Surprisingly, the state objects.
All right, Defense Exhibit 39 is tendered and admitted without objection.
Well, no.
Oh, I'm sorry. Oh, okay,
Text messages that weren't referenced today with, or confronted, with,
okay.
as it relates to Mr. Bradley.
So these are additional text messages, Ms. Merchant?
Yeah, so what I did was they objected that they weren't complete because like the first part of the text wasn't there. It was just like, oh, there was something before that was said. So what I did was I spent this whole time trying to line them up so that I had the beginning of the text, the middle, based on their objection. They have all the text. They can admit all of them if they want them complete. And
All right, how about, I'll just do this. Just, I understand the desire just to have the complete text chain,
Let's talk about that.
just for purposes of completing the record.
Talk about that when we
And,
finish
I
today.
think that there's no point in having him sit here and authenticate every single one of them. So I'm willing to admit it as a court's exhibit. And only the exhibits, though, that had been previously tendered or referenced in testimony would be ones that actually are relied on for making any findings. But just so it's on the record, we have the complete text chain, should that ever be an issue for some reason. Any thoughts about that, Mr. Avati?
My only thoughts are this is not the complete text chain. I'd look
Yeah.
to briefly look at Miss Merchant's phone when she allowed us to have it for
Okay.
seconds, minutes, and there are text messages I know that I saw that are not in what is purported to be State Exhibit 39.
Okay,
it's not
all right.
complete
Ms.
text.
Merchant, what about that?
I let them take screenshots of the ones that they thought weren't there, and he sent them to himself on my phone. I have also offered to hook my phone up to whatever it is. My phone's an iPhone, his is an Android. I can't download like you could in a normal text. I told them if they had a system to get all of my texts, they can have every single one.
Surprise,
We
she
can
has an
definitely do
iPhone.
that.
Your Honor,
Yeah, Mr. Rice.
texts that she's submitting now and tendering into evidence, they are specific parts of the conversation. The entire text chain isn't a continuous conversation subject to 601. Those particular parts, given the witness's testimony, should be admitted as substantive evidence to fire inconsistent statements for this testimony today. We got to the government, the state, if they then want to introduce the rest of it.
I don't think intentionally. I think it was more ineptitude.
Sure, I think that's a fair point that if he had been confronted with a particular text, that could have been the opportunity to admit it as a prior inconsistent statement for impeachment. And some of them were, but apparently some of them were not.
Taking those out. So it's gonna, I'm taking out the ones that they said he wasn't confronted with, and I'm just going to admit the ones that he was. That's fine. It just makes it more confusing, but it's fine.
All right.
It's
so we
weird
have
that
a
anything around
newly
Ashley
marked-
Merchant would be confusing.
Newly compiled 39. Let's see what the state thinks of that one. All right, regardless, if that's now what is being discussed, again, I don't see a need for Mr. Bradley to be here any longer, so I'm going to excuse him at this point. Thank you, Mr. Bradley.
Judge, may we be?
No,
course, take
no
care.
cross.
Yes, that's right.
I think this is a very important question, which I'm going to answer after the court concludes. There were some little nuggets that we got. There were some little nuggets. And in a certain sense, I'll explain to you how it is that getting here itself could ultimately be the win that crushes Fani. And I'll walk you through what I mean by that.
When Ms. Cross had met the witness. I did that. And this was the top one, yeah. Okay, so
So where are we with Defense Exhibit 39?
it might be helpful if you looked at them so you know what we're talking about, but I confronted him with all of
This
these.
is your exhibit 26. You've already got it.
Right, I know. So
you're.
exhibit 26, I put in so that it made sense, so you could read it. You know, when you're reading a text and it's a conversation,
Sure.
they're upset that they're not in order now, I guess. I don't really understand, but if you want to look at them, you can.
Well, let's start from the beginning. What is the purpose of Defense Exhibit 39?
These are the ones that I showed him and that I showed him today. So there were a lot of follow-up questions on it. And so I realized, okay, well, they should just be in the record because other people are referring to my texts and they might as well just be in the record. And he authenticated all of them.
All right.
So
And Mr. Rice?
Not just in the record, Judge, they should be admitted as substantive evidence because it permits prior inconsistent statements.
Okay. All right. So to that end, Mr. Abadi, is there a particular text message in there you think was not authenticated? I understand you're saying, well, maybe one of them's already been admitted. So, but otherwise, just having a omnibus, here are all the relevant text messages exhibit. Is there an authentication objection? Is there any other kind of objection like that?
Yes, because he didn't authenticate that all of the text messages were from him and between Ms. Merchant or the context of them. So I think that's the problem. When you don't, for example, if the state was to provide, I guess, just a specific text chain from a cell phone extraction, there would be an objection because the state would be making the determination as to what is relevant. Really, all the information should be turned over, and it's for the parties to object and Your Honor to determine which parts of the conversation are relevant or not. I don't have all of the conversation. The conversation starts in September, and then so there's a few text messages from September, and then we jump to January. Ms. Merchant has determined that jump in between is not relevant. That's not appropriate. It's for Your Honor to determine what's relevant and not. And I can't make an objection as to what I don't know. I can tell you what I've read. It seems as if there are definitely parts that are missing that would make certain parts of the text message she's attempting to admit that she didn't confront the witness with would be my objection. But only the relevance can only be determined if we have the full chain. So she's determined which ones are relevant. That's your job.
Sure. So, didn't she just try to do the full chain as an exhibit just a moment ago?
No, we don't have the full chain. The full chain is text messages that begin in September and continue.
So
down.
basically, you can't bring it in because it's not relevant, but we need
Okay.
it because it gives context.
Just that chain.
All right.
Which side of his
Ms.
mouth
Merchant,
is talking?
And then I'll, Mr. Gillen.
Not a problem. And I offered that when we were here before, and I was told they didn't have that technology. But let me just go through them one by one. It might be easier. I was trying to just do it quickly all
You
together.
can just hand them to me.
So the first.
Just hand them to me. I can read them. And
and I marked them all separately.
while I'm reading them, Mr. Gillen, what did you have to add?
Brief point, Your Honor. Apparently, Ms. Merchant has allowed the state to take screenshots of what they now contend would be the larger perspective on, and I disagree with them about the rule of completeness, but it's their job when something is admitted that if they have an objection because the context is not appropriate, they then move. And the state should move the rule of completeness, the admissibility of the other emails chain that they had. So the real issue here is their failure to comply with the rule of completeness once they have the material from the last hearing that they took screenshots of.
Well, isn't that what he's doing now? Because now they're being tendered?
I don't think that he is. I mean, it seemed to me that what was happening here is this Ms. Merchant has tried several different ways to get it in. She wanted everything in and they objected to that. And she wanted the segments in that had been, the witness. had
He's
been
just,
asked
he's
about,
saying now what I was
and that's
saying
what she's
60
trying to
seconds
do.
ago.
My point is that if they're, at the time of frankly, of moving under the rule of completeness is at the time of the tendering. If they want to tender something to show that it should be included to be complete, that's on them,
Sure.
not on Ms. Merchant.
All right, Mr. Abadi, last point here.
So I had a very limited time with Miss Merchant's cell phone. I only had time to literally find one part of the text message to then send to myself before Miss Merchant demanded her phone back. So I did not have the opportunity to screenshot every act or every missing part of the conversation to then do as Mr. Gillum is saying that should be done, but it can't be done if I don't have the information. So you don't have the complete packet, and there are many of the text message screenshots that you have printed out that were not used to confront Mr. Bradley or refresh his recollection. So they're inadmissible evidence. If anyone missed the opportunity, it was the defense counsel
Sure.
to confront him.
All right, I don't think we need to go back and forth any further. Ms. Merchant, you've offered, you said, to print out a complete chain of every text exchange with Mr. Bradley since you began corresponding with him. I'll give you the chance to do that, and you can follow up by email with that exhibit. That
Good.
would be the complete chain without any deletions or removals, and we'll have that marked as Defense Exhibit 39.
There you
I
go.
have got to respond though, that
Shut up.
in court
There you go.
Friday at 1:57, when Mr. Abadi texted himself the screenshots, I literally wrote him, do you want any other screenshot? I have nothing to hide. You can download my phone if you want.
Oh my God,
So,
stop it. She's like a little girl.
All right, we're done. Okay, so I'll wait back to hear from y'all on Exhibit 39.
When are we coming back,
and,
Judge? What's the next? What's
Is
next?
there anything else to take up before we discuss Friday?
It is gonna be Friday.
Just kind of throwing it open to the floor.
Closing arguments on
Seeing
Friday.
none. I believe I'd asked and put it out there among defense counsel to be considering how they would like to organize their arguments on Friday. Has there been any decisions reached on that?
To determine that,
Okay.
and I can email the court when we're done with that, but we are going to make it as efficient as possible and break it up.
Break it up in terms of like subject matter or something like that?
There's time limits.
Yeah,
That's large.
yeah,
Let
that's
us know.
that's the idea.
You can tell us what that'll be, and then
Well, I'll start with, what is it that you're asking for? And we'll start there. It's kind of curious.
Well, I don't think
Yeah.
we can answer that right now. Number one, the court said, look, if you divide it up, then we can go with that. Or if you can't divide it up, then I'll give.
Just
each
let Sadow
defense
do it.
counsel a
Just let
specific
Sadow do
period
it.
of time.
Let's do it.
Tomorrow, we'll find out when we meet whether or not we can divide it up in a way that serves the interest of our respective clients. Hopefully we can communicate with the court.
Okay, I'll just wait to hear from you. To the point of, I think the state recently filed their own motion to, I think it formally said to reopen the evidence as to another witness. I only got to read it very briefly, or I don't know if that was just saying in the alternative, we'd like to reopen the evidence. I don't know, maybe someone can clarify that, but my thought there and what I think we ought to do Friday and what I would like to do on the issue of the cell phone analysis and this other affidavit filed by the state today
Give us the cell
is
phone.
that both parties, any party rather, can make whatever arguments they want based on a proffer, any counter arguments they want to make based on a proffer. They would not be admitted into evidence at this point. And at this point, I need to start hearing the arguments in the law and what we've heard so far. And if I think I'm able to reach a ruling based on that, I will. However, if I think that the proffer is going to make a material determinative point, we
This
can
is
reopen
cell
the
phone
at
evidence
that
showing
point. But,
12,000 texts.
just the
and
bottom line is
3,000
on Friday, I do, the intention is that we're still sticking with argument, but the parties are free to address some of these issues that have been brought up post-hearing if they'd like to.
Your Honor, excuse me.
Whoa.
Sorry.
Let me start with Mr. Sadow.
I'm alive and well with a quick question.
All right.
That suggests that we do not have to have a witness present on Friday for the cell phone record, correct?
That's right. Friday would just be argument, and counsel can proffer why they think it's significant. And if once I've heard the law and the argument of counsel, I decide that that is going to have some material bearing on the outcome, then we can reopen the evidence and have it properly admitted and authenticated and subject to cross-examination.
Whoa.
Thank you.
So we have no
Okay.
idea what the hell's
Ms.
happening
Merchant.
Friday.
I just wanted to know if the court wanted us to focus our arguments on anything in particular. Any questions we wanted us to try?
Well, actually, I think what I'm more likely to do is more along the lines of what I suggested before, is give y'all a time block and you use the time however you think is more effective. What you think is your strongest argument. I don't, a lot has been covered, and there's a lot in the motions that weren't covered during the evidentiary hearing that I would plan to rule on at the same time as well. So I leave that to you. Mr. Gillen?
Thank you, Your Honor. I know we have other motions to hear on Friday.
Oh, we do?
I thought we did.
I just said disqualification as a whole. So if you have arguments about forensic misconduct, about anything like that, that would be the time for that argument as well.
I consider that part of the disqualification.
Sure.
I thought we had scheduled hearings on the murder.
No, I mean, I talked about that and then things evolved. So we didn't actually send out a notice adding any other motions, but we do need to. We have some trials starting next week. The next 2 weeks, we've got some of our homicide trials already scheduled. So I'm going to be following up with y'all to schedule the rest of the pretrial motions that we have.
The only arguments that we have on Friday would be 1 o'clock on the issue of disqualification.
And that's right. All things disqualification. Anything from the state or any other defense counsel?
Nothing from the state.
All right. Thank y'all. All right. We're off the record.
Yeah. All right. So they're wrapped up there. So obviously, most of us are disappointed. Not going to kid you. There was some disappointment. I'm going to explain to you why it is that just getting here was a win. It doesn't, look, there's definitely something happening Friday. It's not sure. It's not, the judge to me seemed a little bit vague. It sounds like there's going to be closing arguments on Friday. I do plan on live streaming it. Hopefully Lady Logic doesn't realize that. On Friday night, going into Saturday, we're hosting 60 people here. So she's not going to be very excited about me streaming Friday afternoon. But I do plan on streaming this. I will be here. I will come back for you. But I want to explain to you why it is. Why it is that this is that just getting here help push the needle, because it's reflective about what's going on in the judge's brain. And I started talking about that last night. I really want to finish that up. This is a very important thing as far as understanding where the judge's mind is at. Okay. Well, I'll get there in just one moment. Let me cover a few of these that came in here. Can the judge use info from yesterday for a decision? So if you're talking about info, so this is part of what I think is important here. I think the fact that the judge brought us in here to have this testimony is reflective of the fact here that the judge is very bothered by what he heard here. Can he use that info from yesterday for his decision? This is a tough question. Yes and no. Yes and no. And he's in a very gray area on this. I think this is a really great question. We don't know what they discussed yesterday, other than the fact that after having that discussion, Judge MacAfee basically said, I'm going to allow them to ask questions because there's no privilege here. This isn't relevant to it. Well, how does he reach a determination like that? It has to be that Bradley was talking to him about what he learned about the nature of the conversation and something about the timing, you would think. Something about the timing, which he was very evasive today, Bradley, very evasive about it. I don't know that he gave the timing to the judge. If he did, he's unlikely to have lied about it in front of the judge. That doesn't seem to make much sense. So he probably was somewhat evasive with the judge yesterday as well. But the nature and the context of it, why would he bother bringing us in here today unless the judge already came to some sort of conclusion that it wasn't simply sometime in the summer of 2022? Which leads us to sort of speculate that he's like, yeah, when you're sitting here saying you don't know, I don't really believe you. I don't really believe you. I don't think you're telling us the truth. And all these other bases, I mean, look, there's plenty of reasons to suspect that Bradley was full of crap. And the judge, as the finder of fact, is the one who's determining credibility here. So when he's finding credibility, he's like, yeah, he told me about the relationship. I don't remember when. It's sort of in the judge's call. Do I really believe him when he says, I don't remember when? And it's really hard to separate what he heard in camera from what he heard in court today. And even what he heard in court today, there's a lot of reason. You're all sitting there saying, yeah, you're lying. Yeah, you're lying. We're all sitting there thinking, I'm thinking the same thing. We're all sitting there thinking the same thing. You're full of crap. You don't believe, you're not being straight with us. Some, for one reason or another, you're afraid of actually telling us truth here. So you're sort of left like, how can the judge not see that? How can the judge not see that? This is not a judge who seems to be willfully blinding himself to facts. So in that sense, that's why I say the fact that we got here means the judge already recognizes this relationship did not start. I don't think this relationship started. And I certainly don't think the public, remember, the yardstick is there appearance of impropriety. The public doesn't believe that this relationship started in the spring of 2022. That's pretty clear. That's pretty clear. So there's already, as far as reaching that hurdle of appearance of impropriety, I think the fact that we got to this hearing is a reflection of the judge's recognition that the appearance of impropriety is here. Irrespective of a failure to really land that hammerhead squarely on the nail in court, it's a reflection, to my mind, that the judge likely feels people have a right to hear this. And this should become part of the record. And it's a reflection of, to me, it comes across like there's a reflection in the judge's mind, which is ultimately the only mind that matters, that the public isn't buying this crap. They're not swallowing it. That's what I take from it. Jill, the only reason we're here is Ashley, and to be clear, that I understand, and I've credited her with that. I've credited her with bringing this motion and the diligence that she engaged in. She did. I'm simply saying it's frustrating. It's frustrating her inability to articulate questions. She just seems to be flailing around this way and that way, and it's like, and fixating on things that are not really that relevant. And then she gets snippy sometimes. It's annoying. It's annoying. If the judge refused to kick Fani out of the case, it's because systems corrupt, not lack of evidence, or the defense lawyers not doing their job. Okay. I said, look, I think she's going to get kicked out. I think the judge is going to do it. I think he's going to kick her out. I could be wrong, but it's a tough thing. You also have to realize there's so much at stake for all these people, not just in this one hearing. Here's what they're all looking at. If you're sitting in Judge MacAfee's shoes, he knows at one point he's coming into the limelight where there's going to be millions of people who are mad at him. Could be today. or when I say today, I mean on this motion, not today literally, but I'm saying whenever he decides this motion, it could be, and if he decides in Fani's favor, it'll be months from now when the trial happens, right? But he knows that this is ultimately landing on his lap. Now, I don't know if he wants to go through this whole trial. This is a motivation question. When you look into like motivation of the different actors here, the judge knows if he punts Fani, he's out of this case. It might move on in a different district. It might be in Cobb County or some other county, but it's not going to be his case anymore. Once she's out and her office out, if he rules that way, there is no case for him to be trying anymore. Now, the case doesn't necessarily die. It would probably not be dismissed outright. It'd be transferred to a different court. How that judge handles it, who that judge is, I don't know. I don't think anyone knows today. But the point is, I don't know if he likes this limelight. I don't know if he hates it. I don't know if he's indifferent to it. None of us really know. But that certainly could be a factor if you're looking for as far as biases. That certainly could be a factor in his mind of like, do I really want to be handling this case? And there's a lot of judges who would say, I don't want to be handling this case. So that could be a factor here. Or a lot of judges would be like, oh, hell no, I'm not letting anyone else handle this. I want this case, which would be motivation for him to say, I want this case to move forward. I do think he seems like he's trying to be a judge. He seems like he's trying to rule on things in ways. Most of his rulings today and throughout this entire hearing, I've been like, yeah, that makes sense. That's what judges should be doing. Sometimes I like it, sometimes I don't, but that's just the way, based on the facts and the law, that seems like a fair call here. He's been doing that repeatedly. So in that sense, I'm encouraged by him. Will there be an opportunity to present the phone records, geolocation records into evidence? This is something the judge has not yet decided on. He said he's going to sort of be thinking about that from now through Friday. So we don't know that. The judge led the horse to water and it didn't drink. I think he was disappointed the lawyers didn't get there. He knows something he can't use. This is possibly true. It's definitely possibly true. Like I had a similar feeling. Like he's like, I'm trying to give you the rope. They keep objecting. I keep overruling their objections. But yeah, my point over here on the whole speculation thing is that's why I think that, and I know Tex Vet was arguing with me saying they asked that question. I didn't hear that question here. I did not hear any question. Someone please point me to where it is that they asked. If you form this speculation, that has to be rooted on some observations you saw. In other words, he might not have been told we're in a relationship, but he saw them going to the movies. Could be two friends going to the movies. He saw them going on some boating trip. Are they dating? I don't know. Maybe they're just two people who like boating. But different things that lead him to have the speculation they're in a relationship. That's what I really wanted to get to. And I didn't see any questions on that. All right. So I want to review a few things here. First and foremost, let me get my notepad. Cappuccino in local said, is it fair to say the judge knows the full truth of privileged conversations with Wade? For example, when Wade told him the affair had started based on the in-camera hearing, even though the judge isn't supposed to consider that information. So what I think that we've addressed this, and I'll tell you that I think it's fair to say he knows something, and he's certainly it reflects a lack of trust in Bradley. At the very least, there's a lack of trust in Bradley that Bradley answered properly when he was asserting privilege. Right? That's as a bare minimum. We wouldn't have this hearing today at all if he thought that Bradley was properly asserting privilege. So, Chugi says, I know your frustration, but no matter how she or Sadow asked the questions, I don't remember, or something along those lines was always going to be his response. That's likely true that he was looking to say that as much as possible. And you also said they aren't going to answer, they want out of him no matter who asks questions. I expect this is the way it was going to go. And what I'm saying to you is that doesn't mean you can't ask them. You had to have something that led you to that speculation. Rather than speculation, you didn't speculate that they were mortal enemies. So what leads you to believe that they're not mortal enemies, that they hate each other? Oh, you saw them texting. Oh, you saw them laughing with each other. You saw him touching her arm or her touching his chest or something like that. Things like that. You saw her giving him furtive glances. Whatever it is, you had to see something. That's what led you to the speculation. That's what I want to know about. What did you see that led to that? So you don't know that they're in a relationship. You won't swear under oath, oh, they were in a relationship, but that had to be things you were seeing. Also, the failure to ask him about what did you know with respect to them being in a relationship when you filed for divorce. No one asked him that. You filed for divorce the day after. I mean, that timing is gift wrapped to y'all. It's gift wrapped. The day after. It's not like they had time to form a relationship between when he gets hired and when he files for divorce. You're the one who filed for divorce. What did you know about their relationship at the time you filed for divorce? Nobody asked that question. Asking if we're still acting in a non-professional manner, i.e. romantic ways. That's what Squeaky Wheels sent in a rant. That's very much along the lines of what I was just saying. Real Patriots Party says officially named awaiting ceremony, not a follower, member of the cult that is a not cult type of cult, certainly staffed by a not cult types, and we do not follow our leader that is not a leader. Amen. Well said. SDAPS says, shouldn't they stress that this is a lawyer and as such knew that there were documents in the legal realm and such speculation not be included. I'm not a lawyer, but really, and that's another thing that we got out of this hearing. That's an important point. He really does seem that. Here's what I think is likely the case. When you were looking at him and you were watching Bradley today, did you come to a conclusion that, yeah, he reviewed that motion, and that motion had all these different allegations, and you didn't have any problem with it until all of a sudden now when you're being asked to testify about it? For one reason or another, now you do. And the judge says, okay, we got it. I understand it. And I think the judge recognizes that. Yeah, you gave her this information. You knew where she was going to go with it. You saw her going that way. You never tried stopping her. You're trying to say, well, when I said it, I was only endorsing the 74,000 or some other stupid, irrelevant, immaterial thing that no one actually really cares about. But you weren't actually giving your blessing. I think that I cannot imagine the judge didn't see through that because none of you failed to see it. And he's not stupid. And he doesn't seem to be trying to blind himself to it. And in that sense, that is a significant development from today that we did not have before. That's a significant development, which should not be ignored at all. I think that's a highly significant development, actually. So I'm glad that was called upon because that's great. It's a really important point. Around 2:11, she asked the speculation questions. 2:11 p.m. She never once asked what led him to reach that speculation. I'll go back and look at it. I'll tell you right now. She never once asked what made you come to that conclusion. Even if it was just speculation, what made you come to that conclusion? I'm telling you now. I was watching this like a hawk. I was waiting for that. The judge has seen all the evidence that has not been admitted. Do we honestly think he's not going to take that into account in the end? He's not supposed to if it's not admitted. But I think that at this point, he made it clear that he doesn't really trust the credibility. Right? He makes that clear when he's like, okay, yeah, we got it. That, he signed off and said yes in all these text messages. And all of a sudden now he's saying something different. I'm actually going through a divorce, no court today. Oh, well, I hope that goes well for you. All right. It is 4:40. I need to start wrapping this up here. Friday, we are going to be picking this up. I urge you all, follow me on Locals, goodlogic.locals.com. That's goodlogic.locals.com. Make sure you like and subscribe wherever you are, whether you're here on Rumble, whether you're here on YouTube, whatever you consider here. Make sure you do that. I'd be much obliged. I will see you all probably tonight. I'm still not positive. You'll know whether or not I'm streaming tonight if you sign up, a good look, because I'll give notifications of anywhere I am, whether it's here on this channel or elsewhere, and give you links for that. Free of charge, no money. You just find me, easy. You have to leave notifications on, otherwise it doesn't really do much, but you'll find me easy. No money from you, no money from you. That's at goodlogic.locals.com. I'm going to land my plane here. I thank you all for joining me. I will see you all around 40 minutes in our view. She asks, why? Suck it up. Why could be, why did you speculate? Not what made you come to that speculation. I know they asked, why did you speculate? They asked that over and over again. Okay, I'm going to do this one more time before I get out of here, because I don't know what it is that no one's really understanding what I'm saying here. There's a, why are you doing this versus how did you get to this? These are two different things. So I ask you a question. You give me an answer. Your answer, now you turn around and you say, your answer was not from knowledge, it was from speculation. I could ask you one of two things. Why did you speculate instead of saying, I don't know, which is what Sadow asked a lot. Or I could say, how did, when you reached that speculation to come to that specific answer, what was that based on? Those are two totally different questions. And the word why is so vague that, of course, an evasive person is going to dance around it the way Bradley did. So no, respectfully, y'all are wrong. Not once was he pinned down on how did you reach that conclusion in your speculation? What factors brought you to that specific speculation rather than a different speculation? If I ask you right now, what is the moon made out of? What material is the moon made out of? You might give me an answer. You might say, I don't know. If you say, I don't know, in that case, I say, okay, you don't know. You might say to me, it's made out of mineral. And someone else might say, it's made out of vegetable. And I can say to this one person, and another person might say, it's a gaseous cloud. Right? That could be three different answers. Those are four different answers. I don't know, mineral, vegetable, gaseous cloud. To each of these people who don't say, I don't know person, I can't ask them why. And they say, well, when I gave you that answer of vegetable, I gave you that answer of gaseous cloud, I was speculating. If I say why, what does that why question even mean? Does that mean why were you speculating? Or does it mean how did you reach your conclusion when you said that? I know you didn't know the answer, but what led you think that it was a gaseous cloud? And then you would say, I read it online somewhere. It looks like every cloud I've ever seen before. It looks tasty, like it just grew from the ground. And then if I just rinse off the moon, I could sink my teeth into it. These are two totally different things than why did you give me such a stupid answer? Which is, oh, I gave you such a stupid answer because I was messing with you. It's not the same question. So all you people who are yelling at me that they asked it, respectfully, I disagree. They asked why he speculated, not what was his speculation rooted in. Anyway, I think we covered it. All right. Goodlogic.locals.com. Make sure you like and subscribe wherever you are. I think I'm going to stream tonight. I'd like to talk about Michigan and stuff like that. If I do stream, it's going to be late. You'll know what time that is if you sign up goodlogic.locals.com. I'm landing my plane here. Lady Lodge is going to want me to leave here in like 45 minutes. I got to work really fast. I will see you all soon. Maybe tonight. Almost certainly going to do a local stream tomorrow. So there you go. Stay happy. Eat some bugs. And as always, my friends, Walt Speed.